Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the probate, civil, and family law docket for Thursday, July 16, 2026. The time is now 9:07. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator, interpreter, and court coordinator for this hearing. Ms. Liza Rodriguez is the probate court investigator. Mr. Armando Lopez is the staff attorney. Video conference co-hosts this morning include Ms. Ramos, Ms. Cuellar, and Mr. Hernandez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum. Wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Rodriguez.
First in counsel, George Altco. My apologies. I'm assuming page 8, number 21, Mr. Goldsmith.
State of Texas versus Ismael Contreras. In the matter of Ismael Contreras, cause number 2026 CVJ 1216C3. Court marks Mr. Goldsmith present in person. Good morning.
Good morning, Your Honor.
Ismael Contreras, are you present?
I believe he's
Yes, I'm present, sir.
attending via Zoom.
Yes, sir, I'm present.
Are you Ismael Contreras?
Yes, Your Honor.
Welcome to court. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present in person. Mr. Goldsmith, what is the announcement?
Your Honor, in this matter, Ms. Contreras is present. I need to prove up a occupational license.
Mr. Contreras, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand. Mr. Goldsmith, go ahead.
Thank you. Mr. Contreras, my name is Trace Goldsmith. I'm appearing from Mr. George Altfield. I have a few questions to ask you. If you do not understand, let me know. I will repeat them or rephrase them so you do understand.
Yes, sir.
Mr. Contreras, please state your full name for the court's record.
Ismael Contreras,
When were you born, Mr. Contreras?
January 12, 2000.
Where are you currently living? What is
In Laredo, Texas.
what is the street address?
1003 Emerald Valley Drive in apartment 33.
Okay. Is that in Webb County?
Yes, sir.
What is the current number of your Texas driver's license?
Yeah, it's okay to only give the last 3 digits. We're live.
Please tell the court what the last 3 digits of your Texas driver's license are.
Last 3 digits of my driver's license. It is 241.
Is that a Class C operator's license or a commercial license?
Class C.
When were your driving privileges revoked, Mr. Contreras?
I believe on the 8th of this month, July 8th.
Okay. When did you receive notice that that your privileges were being revoked to operate a motor vehicle on a public thoroughfare? Or let me ask you this: was this on about early March of this year?
Yes, sir.
Okay. Why were they revoked? Why were your privileges revoked?
Due to DWI refusal.
Are you currently covered under auto insurance?
Yes, sir.
Who provides that insurance?
I believe I have it with Allstate.
Now, your driver's license was not revoked due to a non-payment of child support.
I'm sorry, can you repeat that?
Your driver's license was not revoked due to non-payment of child support.
No, sir.
And it was not revoked due to a finding of mental disease or defect.
No, sir.
Um, You've not been granted an occupational license more than twice in the last 10 years.
No, sir.
Why are you requesting an occupational driver's license of the court at this time?
I do need I need a drive from here from my apartment to work. I do have a pretty flexible schedule there at my job. I don't have a set schedule. The operating hours there are Monday through Sunday, which being Monday through Friday is 7 a.m. to 7 p.m., where I can work possibly from 6:30 in the morning or 6 a.m. in the morning, all the way till sometimes past 9 p.m. And then on the weekends, which is Saturday and Sunday, my working hours can range from anywhere. We open at 6 in the morning, all the way to 4 p.m. So they can range from me driving approximately around 5:30 in the morning to around 6 p.m.
Now, who do you work for? Who are you employed by?
My employer is Grifols Plasma Center or Biomat Grifols. It's on 815 Grant Street.
Okay. And it's true that you are a licensed vocational nurse?
Yes, sir.
Okay. And you're also, in addition to the scheduling, the work schedule, you're asking for an additional 30 minutes before and after to travel from your residence to your place of work and back again.
Yes, sir.
Pass the witness, Your Honor.
So I have a couple of questions. First question, I think it's to, well, let me ask you, Mr. Goldsmith, has Mr. Contreras provided a driving record or proof of insurance?
I'm not sure, Your Honor. I know the times that he's requesting, I read in the petition for
Yes, please. All right. I just want to confirm, was that on the record? Court has heard, yes. All right, so first thing, Mr. Contreras, I'm going to consider this by submission as soon as you file your SR-22, which is your proof of insurance. I can't grant that. No court can grant that unless you show proof that you are actually insured. This is your SR-22. Second, under Texas law, the court can grant a maximum of 12 hours in a 24-hour period. You're actually requesting 16. You can't, I can't grant that. So knowing what you know about your job, your employment, when the
Right.
hours of operation are and your schedule, what 12 hours in a 24-hour period would you like the court to consider granting?
I would say I believe 7 a.m. to 7 p.m.
All right. Anything else on this case, Mr. Goldsmith?
not at this time, Your Honor.
So let's do this. Mr. Goldsmith, file the proof of insurance, the SR-22, and file an amended order that grants driving privileges in Webb County Monday through Sunday. Or I guess reverse, Sunday through Monday from 7 a.m. to 7 p.m. And I'll consider that and sign that by submission as soon as it comes in.
Very good, Your Honor. I will take care of that forthwith.
All right. Do you have any questions for the court, Mr. Contreras?
No, sir. Thank you, Your Honor.
Yes, sir. The court will sign off on that as soon as they're filed. I wish you all the best, sir. Have a good day.
Thank you.
Orders due August 24th, along with the SR-22.
This is due on or before August 24th, but I'll sign off on them as soon as they're filed. Any other cases for Mr. Altgeld or Mr. Goldsmith?
No, Your Honor, not that I'm aware of.
Have a great day.
Yeah,
Good to
you
see you.
too. Thank
Yes,
you.
sir.
Next in person, Council Philip Del Rio, page 8, number 20.
This is in the matter of Raimundo Moreno, cause number 2026 CVJ 1156C3. Good morning, Mr. Del Rio.
Good morning, Your Honor.
Court Martial President in person, speak into the microphone and tell the court, are you Raimundo Moreno?
This is, Your Honor.
Welcome to court, Mr. Moreno, the court martial president in person. The person to your right is your lawyer, Mr. Del Rio. Are you ready to go forward?
Yes, Your Honor, we're ready to proceed.
Mr. Moreno, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand, Mr. Del Rio.
Yes, Your Honor, before I begin, I'd like the court to take judicial notice of exhibits A, B, and C, which respectively are the SR 22, the driving record, and the letter of employment.
Notice so taken.
Thank you, Your Honor. Mr. Moreno, are the last three numbers of your driver's license 166?
Yes,
And you reside in Webb County, Texas?
yes,
And on or about June 10th, 2026, your license was suspended for an offense that occurred within Webb County, Texas.
yes,
And you are currently employed with a petroleum company, is that correct?
yes,
And as part of your duties and responsibilities, you need to operate a regular vehicle, not a commercial vehicle, correct? Correct. And that some of those responsibilities require you to visit sites that are located not only in Webb County, but LaSalle County and Frio County, correct?
that's right.
And you're asking this court to grant your occupational license, which would allow you to drive within your employment hours of Monday through Friday between 6 a.m. and 5 p.m. Is that correct?
That is correct.
And there is essential need for you to have this occupational license in order to perform your duties of transportation for your profession and trade, correct? That's it. Or no further questions.
Mr. Moreno, in your case, cause number 2026 CVJ 1156C3, the court takes judicial notice of the entire case file. The court finds that it has jurisdiction. The court sees that you have filed a verified application, your proof of insurance, your driving record, your letter of employment. The court finds that you are currently employed. Your license has been suspended. The court finds that there is a necessity for you to drive for purposes of work. The court hereby grants your request.
Thank you, Your Honor.
Thank you, Judge.
The court has signed an order and you're allowed to work Monday through Friday, 6 a.m. to 5 p.m. The court is tendering the original signed order to the clerk's office. Do you have any questions for the court, Mr. Moreno?
No, thank you, Your Honor.
I wish you all the best. Have a good day.
Thank you, Your Honor. Your Honor, if the court would allow, I was hoping to make an announcement on another attorney's behalf, Mr. Andy Reyes, on page 10, in Garza versus Garza.
Yes, sir.
Thank you.
Garza versus Garza, Oscar Garza Jr. versus Sonia Patricia Garza, cause number 2026 FLA 1030C3. Court marks Mr. Philip Del Rio present in person on behalf of Mr. Reyes. Mr. Garza, Mrs. Garza, if you're present, please step forward. Please speak into the microphone and tell the court, are you Oscar Garza Jr.?
Yes, Your Honor.
Welcome to court, Mr. Garza, the court martial present in person. Sonia Patricia Garza, are you present? Court finds respondent not present and court sees that service has not been effectuated. Mr. Del Rio.
Yes, Your Honor, as you correctly noted, the issue is service, Judge, and so Mr. Reyes is respectfully requesting an extension of the TRO, given the fact that the respondent still has not been able to be served due to inavailability. I don't know if he's going to need to file a motion for substitute service at this point, but service has not yet been effectuated, so we are requesting the legally allowed extension under the rules.
Well taken. The TRO extends and court will set this hearing for
July the 30th at 2 p.m.
Right, so come back to court on July the 30th at 2 p.m. and between now and then keep in contact with your lawyer, Mr. Garza. Do you have any questions for the court?
No, Your Honor.
I wish you well, sir. Have a good day.
Thank you, Your Honor.
Any other cases for Mr. Del Rio or Mr. Reyes?
No, Your Honor.
It's good to see you, counsel.
You too, Judge. Thank
Have a
you.
great day.
Thank you. Likewise.
Next in person, Council Robert Lucas, page 6, number 15.
Page 6, 15. Macy Perez versus Cornerstone Fitness Texas LLC DBA True Fit Athletic Clubs, cause number 2025 F scratch 2025 CVF 2302C3. Good morning, Mr. Lopez.
Good morning, Judge. I represent the plaintiff, Nancy Pettis, Your Honor. We're set for a final pretrial today. My office filed a no answer default judgment on this case yesterday. I don't know if the court has it or not, but it is filed. Our trial date, I believe, is set for August the 4th, if I'm not mistaken. I would ask the court to set this for a hearing on our no answer default judgment.
On that day?
I think that would work, Judge.
Sure. So just for purposes of the record, August the 4th at 2 p.m. is the jury selection conference date. Jury selection to begin August 21st at 8 with the jury trial on August 24th at 8 a.m. The request is to set this default for August the 4th. It is well taken.
Your Honor,
Yes.
you read the notes on number 14.
Excuse me. You are absolutely right. This is set for a bench trial on August the 4th, period, full stop. And that's a request to set this for hearing on that date.
Yes, Judge, and I think because this is a hearing for, we're gonna probably need two hearings. We'll need the one for the no answer default, and then we'll need a subsequent hearing for the to determine the amount of damages. So I don't know how you want to handle that.
Sure. It's we're gonna leave this one for bench trial. And then we'll open up a second setting for the continuation thereof. Give me the very next setting after August the 4th.
August 18th at 2 p.m.
So ordered.
Can I just check my calendar?
Absolutely.
Create a conflict. I should be fine on this today.
All right. We'll come back for the first part of that bench trial and default on August the 4th at 2 and the final conclusion on August 18th at 2 p.m. All right. Any other cases for Mr. Lopez?
Page 7, number 17, as guardian ad litem.
This is Angelica Arispe versus Quora Haulers LLC, Carlos Rodriguez, cause number 2026, CVA 742C3. Court marks Mr. Lopez, present in person. Lawyers, counsel, Ezequiel Reina, Mark Macias. Any lawyers present?
Your Honor, Daniel Saldana on behalf of Mark Macias and the defendants.
Judge Marco Cepeda here with the Law Office of Ezequiel Reina for the plaintiff.
Mr. Saldana and Cepeda, welcome to court. The court marks you both present and participating by video conference. Angelica Arispe, Carlos Rodriguez. Any other persons, parties, witnesses, any other persons present? Court finds no other persons are present. Counsel, what is the announcement?
Your Honor, this case is set for a calendar call. I don't think we need to enter into a guideline order. I'd ask the court set this for a minor settlement hearing. I have been able to speak to the plaintiff's mother last night, and I don't think this is we don't need much time on this. We just need to prove up the hearing, so I can be ready in short order, whatever the court wants to.
Well taken. Thoughts, comments, questions, or objections, Mr. Saldana?
I don't have any objections, Your Honor. The case is settled. The last thing that remains to be done is just the friendly suit prove up. And so I guess the next, if Mr. Lopez is ready, I guess the next available time for us to set the friendly suit here, and we'll make ourselves available.
Mr. Cepeda?
The same announcement, Judge.
I think you're set to come back on that last case on August the 4th. Any objection to that date?
Not at all, Judge. We can get it done by then.
All right, August the 4th then.
Your Honor, we have a full docket
Give us the next setting then.
on August 18th at 2 p.m.
Any objections by any persons?
No objection, Your Honor.
I don't have an objection, Your Honor, but August 18th at what time, Your Honor?
2 p.m.
2 p.m. Okay. We'll make ourselves available, Your Honor. Thank you.
All right. Any other cases for Mr. Lopez?
No, Your Honor.
It's good to see you, counsel. Have a great day.
Likewise.
Thanks,
Mr.
Judge.
Saldaña, Mr. Cepeda, good luck to all. Have a great one.
Okay, thank you, Your Honor.
Next in person is Counsel Eduardo Romero, page 5, number 12.
This is the estate of Jaime Rene Flores, also known as Jaime Rene Flores Gutierrez, cause number 2026, PB 438L2. Court marks Mr. Romero present in person, Mr. Vela present in person. Mr. Fernando Sanchez, are you present?
Not identified.
Court finds Mr. Sanchez not present. Maria Veronica Cuellar, Claudia Blanchett, Jaime Rene Flores Jr., Norma Flores. Any parties present? Court finds Maria Veronica Cuellar present in person. I'm sorry, Sergeant. What was the name of the second person? And Norma Flores present. Are you Maria Veronica Cuellar?
Yes.
Welcome to court. You're present in person. The person to your left is your lawyer. Speak into the microphone, Ms. Flores, and tell the court, are you Norma Flores?
Yes, sir.
Interpreter.
Welcome to court. The court marks you present in person.
Bienvenida al tribunal. El tribunal la marca presente en persona.
The person to your right is your lawyer.
La persona a su derecha es su abogado.
Counsel a little slower than normal. Go ahead.
Your Honor, we are set, if I'm correct, we're set for the application to determine errors, to name an independent administrator, and then I also filed a companion motion for the withdrawal of funds.
Translation.
Su señoría, estamos aquí para la aplicación para interponer administrador temporal para determinar los herederos y también interpuse la aplicación para poder obtener los fondos del registro del tribunal.
Those are your requests this morning.
Yes, Your Honor. However, Mr. Fernando Sanchez has advised us that he is not ready to move forward.
Eso es lo que están pidiendo el día de hoy. Sí, su señoría, sin embargo, el abogado Sánchez me ha dicho que él no está listo para proceder el día de hoy.
So the only motion that I wish to proceed today would be for the motion to withdraw the funds.
Entonces, nuestra petición del día de hoy será para obtener fondos del registro.
Have you had an opportunity, excuse me, have you had an opportunity to talk to Mr. Vela this morning?
Yes,
¿Han tenido oportunidad de hablar con el señor Vela? Sí.
I do not oppose Mr. Romero's request to withdraw the funds from the registry of the court. I have no opposition to that.
No nos oponemos a que el abogado Romero pueda obtener los fondos de registro, su señoría.
Cause number 2026 PB 438L2. The court takes judicial notice in the entire file. The court has received, reviewed, and considered the motion to withdraw funds from the registry of the court. The amount requested is $5,000. In response, there is no objection. It is well taken and so ordered.
No hubo objeción a que se retirara del fondo del registro del tribunal $5,000, así se ordena.
The court has reviewed an order to that effect. It is signed.
El tribunal ha revisado la orden, está en efecto y ha sido firmada.
The court has tendered the original to the clerk's office.
El tribunal le ha otorgado la original a la Secretaría del Condado.
Mr. Romero, did Mr. Sanchez indicate how much time he would require?
at least a few weeks.
Abogado Romero, el abogado Sánchez, le comentó a usted cuánto tiempo necesitaría él, al menos un par de semanas.
Ms. Rodriguez, what would be the next available setting?
September 15th,
At
2 p.m.
any objection, Mr. Romero?
No, Your Honor.
Mr. Vela?
No, Judge.
All right,
And this would be for pretrial, Your Honor?
this is the application for temporary administration.
So final hearing on the application?
This is just for the temporary administration.
No, it would be for the actual, the permanent.
Oh, this is for the entire.
Yes.
All right.
Yes.
Well taken and understood now. Final hearing.
Judge, may I make just a few points?
Yes, sir.
Mr. Romero and I have been working together to try to get all of the potential assets that may be involved in the estate so that we can have an informal settlement conference among the parties.
Su señoría, si me permite hacer el anuncio, el abogado Romero y yo hemos estado trabajando para obtener información sobre todos los bienes y poder tener una conferencia informal entre todas las partes.
I also filed a counter application for a dependent administration. And I would like my motion to be set as well. But in the meantime, Mr. Romero and I will continue to work on a potential resolution.
Por mi parte, he interpuesto y archivado una contraaplicación para interponer una administración dependiente y me gustaría que esa moción fuera puesta ante el tribunal. Sin embargo, el abogado Romero y yo seguiremos trabajando en conjunto para llegar a una resolución.
Counter application for dependent administration is hereby scheduled for and set for hearing September 15th at 2 p.m.
Thank you, Judge.
Your Honor, in conjunction with what Mr. Vela stating that we have tried to work with each other. I had issued a subpoena to Ms. Flores. The documents were actually due back on May 18th.
Su señoría, en respuesta y el hecho de que estamos trabajando en conjunto para llegar a la resolución, habíamos interpuesto una orden para que la señora Flores produjera documentos y esos documentos debieron de haber sido entregados el 18 de mayo.
Ms. Flores has been tendering the documents, but not fully. And so what I've asked for Mr. Vela to maybe avoid the necessity of me serving discovery is that I will submit to him through email the information that I believe we still might be missing. He has agreed to tender them within 5 days and to hopefully avoid the actual request for interrogatories or production.
Translation, please.
Su señoría, y aunque la señora ha estado otorgando documentos, no han sido los documentos en su totalidad. Entonces le he pedido al abogado Vela para evitar tener que pedir descubrimiento, que si a través de un correo electrónico él me podría mandar la información que le daré como la que hace falta. Él dijo que dentro de los próximos 5 días podría producir esa información y así podríamos evitar el descubrimiento.
Mr. Vela.
That's correct, Judge. If there is anything that Mr. Romero feels is missing, I will ask my client and we will produce. And if we don't, he can serve me with discovery. We've been working in a cordial manner in this matter.
Es correcto, su señoría. Le he comentado al abogado Romero que él me mande un listado de lo que él siente que aún hace falta en cuanto a documentación y si es que le pregunto a mi cliente y mi cliente no lo tiene, entonces le he dicho al abogado Romero que él me puede dar el descubrimiento y con mucho gusto entraremos en en ese intercambio de documentación, ya que estamos trabajando de manera cordial.
Any other announcements?
No, Judge.
¿Algún otro anuncio? No, su señoría.
Ms. Cuellar, Ms. Flores, your lawyers have now presented one of the best announcements that can be made on the record.
Señora Cuellar, señora Flores, sus abogados han hecho uno de los mejores anuncios que están ante el récord.
I disagree on the outcome, but you certainly work together to get to a finish line, whatever that outcome may or should be.
Puede ser que ambas estén en desacuerdo en el resultado final, sin embargo, están trabajando para llegar a el final, cual sea el final que resulte.
So continue to talk to your lawyers, work with each other. Anything that you can't agree, I will order in your case.
Continúen hablando con sus abogados. Lo que sea que ustedes no estén de acuerdo, este tribunal podrá ordenar lo que sea de acuerdo a la ley.
I wish you both very well. Have a
Le
good day.
deseo bien a ambas.
Thank you, Judge.
Those
Thank you,
are all
Honor.
the matters before the corporate counsel, Romero and Vela.
Good to see you both. Have a great day.
Next in person is Counsel Gabriel Nieto, page 9, number 23.
This is in the matter of Julio Cruz, cause number 2026, CVJ 1259C3. Court mark Mr. Nieto Garcia, present in person. Speaking to the microphone, sir, and tell the court, are you Julio Cruz?
Your Honor, if you may request an interpreter.
Habla ante el micrófono, ¿es usted Julio Cruz?
Sí.
Yes.
Welcome to court. The court marks you present in person.
Bienvenido al tribunal. El tribunal le marca presente en persona.
Person to your right is your lawyer.
La persona a su derecha es su abogado.
Counsel, what is the announcement?
Your Honor, we're here on a petition for an occupational driver's license. I have a few questions if I may ask my client.
Su señoría, estamos aquí para pedir una licencia ocupacional y está interponiendo esta petición a nombre de mi cliente.
Mr. Cruz, would you raise your right hand, please?
Señor Cruz, por favor, levante su mano derecha.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
¿Jura o afirma que el testimonio que dará ante el día de hoy será la verdad bajo el amparo de Dios?
Sí.
Yes.
You may lower your hand. Mr. Nieto, go ahead.
Thank you, Your Honor. Can you please state your name for the record?
Por favor, diga su nombre completo para el récord.
Julio Cruz.
Julio Cruz.
And what is your date of birth?
¿Cuál es su fecha de nacimiento?
0106 de 1967.
0106 of 1967.
Are you a resident of Webb County, Texas?
¿Es usted un residente del condado de Webb, estado de Texas?
Sí.
Yes.
Can you confirm your current address for the record?
¿Puede confirmar su dirección actual para el récord?
548 Pitaya. Right.
548 Pitaya
Right.
Drive.
Do you hold a Texas driver's license?
¿Tiene usted una licencia de manejo del estado de Texas?
Sí.
Yes.
And the last three numbers of your license are 216?
¿Y los últimos tres números de su licencia son 216?
Sí.
Yes.
Has your Texas driver's license been suspended?
¿Su licencia de manejo del estado de Texas ha sido suspendida?
Sí.
Yes.
And your license was suspended on July 5th, 2026, correct?
Y su licencia fue suspendida el 5 de julio de 2026, ¿correcto?
Sí.
Yes.
And was the suspension related to an alleged DWI offense?
Y esta suspensión fue debida a una alegación de manejo bajo intoxicación.
Sí.
Yes.
And that occurred in Webb County, Texas?
Y eso ocurrió aquí en el condado de Webb.
Sí.
Yes.
Have you previously had your license suspended for any alcohol or drug-related enforcement contact within the past 5 years?
¿Usted ha tenido su licencia suspendida en los últimos 5 años debido a alguna alegación que incluya alcohol o drogas?
No.
No.
Have you ever previously obtained an occupational driver's license?
¿Usted había obtenido una licencia de manejo ocupacional de manera anterior?
No.
No.
Have you ever failed to comply with any prior court orders related to licensing or driving privileges?
¿Usted no ha cumplido con las... Excuse me, can you repeat again?
Yes, of course. Have you ever failed to comply with any prior court orders related to licensing or driving privileges?
¿Usted ha fallado en cumplir órdenes del tribunal relacionados con privilegios de manejo?
No.
No.
And your job requires you to drive to certain locations, correct?
Y su trabajo requiere que usted vaya a ciertas locaciones, ¿correcto?
Sí.
Yes.
So without a license, you wouldn't be able to get to and perform your job duties, correct?
Y si usted no tiene una licencia, usted no tendría la manera de llegar a su trabajo y hacer sus responsabilidades, ¿correcto?
No.
No. Yes.
No.
Do you also have an essential need to drive for household purposes such as caring for your family and purchasing necessities?
Y usted también necesita una licencia para poder cumplir con cosas esenciales del hogar, como cuidar a su familia y obtener necesidades del hogar.
Sí.
Yes.
Who is your current employer?
¿Con quién está trabajando actualmente?
Eco Bricks
E-
Solution. Eco Brick Solution.
Eco Bricks
Solution.
Solutions.
And your job duties require you to drive a vehicle?
Y una de las responsabilidades de su trabajo es que usted necesita manejar un vehículo.
Sí.
Yes.
And what geographic area does your job duties cover?
¿Y qué área geográfica cubre su trabajo?
El sur de Texas.
The South of Texas.
Are you required to drive a company vehicle as part of your employment?
Y usted debe de manejar un vehículo de la compañía como parte de su empleo.
Sí.
Yes.
Do you currently maintain a valid liability insurance policy as required by Texas law?
Y usted actualmente tiene un seguro en cuanto a daños a terceros de acuerdo a la ley de Texas.
Sí.
Yes.
When does your current insurance policy expire?
¿Cuándo expira esta póliza?
Enero del próximo año.
January of next year.
And you're requesting that you be allowed to drive Monday through Friday from 6 a.m. to 6 p.m. to fulfill your job obligations?
Y usted está pidiéndole al tribunal que a usted se le otorgue la petición de manejar de lunes a viernes de 6 de la mañana a 6 de la tarde para cumplir con sus obligaciones.
Sí.
Yes.
And on the weekends, are you requesting that you be allowed to drive from 6 a.m. to 6 p.m. to fulfill your household duties?
Y los fines de semana de 6 de la mañana a 6 de la tarde para cumplir con sus responsabilidades del hogar.
Sí.
Yes.
And as far as counties in which you are requesting you be allowed to drive, these consist of Webb, Zapata, Jim Hogg, Dimmitt, LaSalle, McMullen, Hidalgo, Starr, Rio, Brooks, Live Oak, Duval, Jim Wells, Bear, and Zavala counties. I'm sorry,
Webb, Zapata,
Jim Hogg, Dimmitt, LaSalle, McMullen, Hidalgo, Starr, Rio, Brooks, Live Oak, Duval, Jim Wells, Bear, and Zavala.
y usted debe de manejar por los siguientes condados debido a sus responsabilidades de trabajo: condado de Webb, Zapata, Jim Hogg, Dimmitt, LaSalle, Frio, Brooks, Live Oak, Zavala, Bear, McMullen, Hidalgo, Starr, Duval, Jim Wells.
Sí.
Yes.
Do you understand the limits on hours and areas that the court may impose with this license?
¿Usted comprende los límites en horas y en áreas geográficas que este tribunal puede imponer?
Sí.
Yes.
And are you willing and able to comply with these restrictions if set by the court?
¿Y usted está dispuesto a cumplir con cualquier restricción que este tribunal pueda imponer ante?
Sí.
Yes.
Will you follow all of the court's orders regarding this occupational license if granted?
¿Usted seguirá todas las reglas de esta orden de licencia ocupacional si es que se nos otorga?
Sí, claro.
Yes, of course.
Are you asking the court today to grant your petition for an occupational driver's license subject to any necessary restrictions?
¿Y usted le está pidiendo a este tribunal que otorgue su petición para que se le otorgue a usted su licencia de manejo ocupacional, aunque pueda ser con restricciones?
Sí.
Yes.
Pass a witness.
Mr. Cruz, in your case, cause number 2026 CVJ 1259C3, the court finds that it has jurisdiction over your case.
Señor Cruz, en su causa, el tribunal halla que tiene jurisdicción sobre su asunto.
The court takes judicial notice of the entire case file,
El tribunal toma notificación en su totalidad de el archivo,
which includes your verified application,
el cual incluye su aplicación verificada,
your proof of insurance,
su prueba de seguro,
your driving record,
su récord de manejo
and your letter of employment.
y su carta de empleo.
The court finds that your license has been suspended,
El tribunal halla que su licencia ha sido suspendida,
but the court finds that there is a necessity for you to continue to drive for purposes of employment.
y el tribunal halla que usted tiene la necesidad de seguir manejando para propósitos de su empleo.
The court finds that you work in the South Texas counties listed,
El tribunal halla que usted trabaja en los condados enlistados,
both in your application and now as part of your testimony.
ambos mencionados en su aplicación y ahora como parte de su testimonio.
The court hereby approves your request and will allow you to drive in those counties from 6 a.m. to 6 p.m.
El tribunal otorga su petición y le otorga a usted el derecho de manejar de 6 de la mañana a 6 de la tarde por medio en esos condados.
These are the orders of the court, and the orders are due to the court honor before
July 27. Estas órdenes deberán de ser entregadas al tribunal antes del 27 de julio.
Mr. Nieto. I didn't see any proposed orders in the case file, but as soon as they're filed, I will sign off on those.
Thank you, Your Honor, will do.
Do you have any questions for the court, Mr. Cruz?
¿Alguna
No.
pregunta para este tribunal, señor?
No.
No.
I wish you well, sir. Have a good day.
Gracias.
Buen día. Those are all the matters before the court for Counsel Nieto Garcia.
Good to see you, counsel. Have a
Thank
great
you,
one.
Honor. Likewise, see you.
Next in person, Counsel Jose Diaz II, page 2, number 3.
This is the estate of Francisco Galarza III, cause number 2023 PB 484L2. Court marks Mr. Diaz present in person. Leticia Lizette Peña, are you present?
We filed a motion to she is not present. We filed a motion to extend our deadline to file an inventory. This was just granted a couple months ago, and there was a pending sale of the property which would materially affect the inventory and render it inaccurate. So we're just asking for a little bit of time.
Court has received, reviewed, and considered the application for extension of time to file an inventory appraisement and list of claims. It is well taken. The inventory on this case is now due on
How much time, Your Honor? The 90 days?
the request, I believe, says for 30, but give us the next available. So sometime in September.
September 15th at 2 p.m.
All right. Any other cases for
Page-
Mr. Diaz?
For number 9,
The estate of Elba Chapa Cardenas, cause number 2025 PB 750L2. Court marks Mr. Diaz present in person. Aide Figueroa, are you present? Court finds Ms. Figueroa not present. Mr. Diaz.
Your Honor, we filed a motion to convert the temporary administration to a permanent administration along with the proposed order. This case has previously been approved for temporary administration. And it was set for expiration, I believe, August 2nd, 3rd of.
You can't hear me. Cause number 2025 PB 75002. The court hereby takes judicial notice of the entire case file. Court finds that the court had previously granted a temporary administration. The court finds that all of the requisites necessary to grant this request are in the case file and as part of the evidence presented at the previous hearing. And the court hereby grants a request and converts this administration into a permanent one. Court has received, reviewed, and considered an order to that effect. The court has signed it and tendered the original to the clerk's office. Anything else on this case, Mr. Diaz?
No, Your Honor.
Ms. Rodriguez?
page 6, number 14.
Mark Anthony Eliff versus Dagoberto Adubes Anaya, cause number 2025 CVA 445C3. Court marks Mr. Diaz present in person. James Ray, are you present? Court finds opposing counsel not present. Mark Eliff Dagoberto Anaya. Any parties present? Or Ana Rosa Contreras. Any parties present? Court finds no other persons are present. This is final pretrial hearing. Mr. Diaz?
Your Honor, we settled this case. I anticipate there being a motion for non-suit with prejudice to be filed shortly. I don't know if the court can just set us for either entry of judgment or a status hearing in 30 days. Everything has been finalized. It's just signing off on the paperwork.
Ms. Rodriguez, let's cancel all settings and give us an entry of judgment day. Entry of judgment day.
That's why I was going to ask for, everybody likes that say entry of judgment, but it's not really. It's going to be a motion for non-suit.
Yeah. Let's just convert the whole thing to a final hearing in 45 days or so.
September 15th at 2 p.m.
All right. So as long as something is filed before then, it'll come off the docket.
Okay, perfect.
Any other cases for Mr. Diaz?
I have one last case, Judge.
Page 9, number 22.
22. Saul Hector Carrion, 2026 CVJ 1250C3. Court marks Mr. Diaz present in person. Speak into the microphone, into your device. Tell the court, are you Saul Carrion?
Mr. Carrion, you need to take yourself off of mute.
Believe the device is frozen. Are you Saul Hector Carrion?
Yes, sir. My name is Saul Hector Carrion.
Welcome to court, sir. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present in person. Mr. Diaz, are you ready to go forward?
Yes, Your Honor.
Mr. Carrion, would you raise your right hand?
Okay.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir. I do.
You may lower your hand. Mr. Diaz, go ahead.
Yes, please state your true and complete name.
My complete name?
Yes.
Saul Hector Carreon.
And are you the same Saul Hector Carrion that resides at 2822 Don Sergio here in Laredo, Texas.
Yes, sir.
And your driver's license and driving privileges were suspended on or about March the 7th of 2026 for DWI offense, which allegedly occurred in Webb County, Texas.
Yes, sir.
And you have an essential need to operate a motor vehicle in order to seek and complete gainful employment, correct?
Yes, sir.
Okay, and if not having a driver's license constitutes a hardship, a serious hardship upon you and your family?
Yes.
All right, and you are employed, I apologize, with the Little People Learning Centers?
Mr. Carrion?
Yes.
Okay, and they have several locations throughout Webb County as well as Ensenada, Texas, correct?
Yes, sir.
Okay. And you're asking the court to grant you an occupational license for the dates and times that are mentioned in the petition, correct?
Yes, sir.
I have no further questions, Your Honor. Your Honor, I'd ask the court to take judicial notice of the court's file, the exhibits A, B, and C. It's the exhibit A is the letter from the employer from Ms. Ruby Cristina Flores Tamez. B is the SR 22. Exhibit C is his driving record from DPS, which shows that he's never received an occupational license in the past. And we're asking the court to grant the proposed order. I believe the proposed order will fall on July the 10th.
Mr. Days, the court takes judicial notice of the entire case file. I've reviewed the law, and I guess the only thing that needs to be satisfied is the court's determination about public safety based on the driving record. What should the court know?
Pardon me, Your Honor, on the exhibit C.
Well, this would be, yes, sir.
And his driving record, I don't understand the court question.
What, if anything, would you like the court to know and consider regarding that record?
Oh, I'm sorry, just that he had not previously had an occupational license in the past 5 years or 10 years. Like, this is his first occupational license request, otherwise it would have been reflected in the DPS exhibit. He has no previous suspensions for DWI. It's just that this is the first time he's ever asked for an occupational license.
Mr. Carrion, in your case, cause number 2026 CVJ 1250C3, the court at this time finds that it has jurisdiction over your case. The court takes judicial notice of your entire case file, which includes your verified application, your letter of employment, your proof of insurance, and your driving record. The court finds that your license was suspended in March of this year. The court sees that you are gainfully employed. You are financially responsible. You have financial responsibility over your vehicle. The court finds that you are employed and that employment requires you to work Monday through Sunday, 8 through 8 p.m. The court grants your request and allows you to travel for purposes and drive for purposes of the work in Webb and LaSalle counties from 8 to 8 a.m. to 8 p.m. Monday through Sunday.
Yes, sir.
The court has reviewed an order to that effect. It is in due form. The court is signing that order and tendering the original signed order to the clerk's office. Mr. Carrion, do you have any questions for the court?
No, sir.
Have a good day, sir. I wish you well.
You do. Thank you, sir.
Any other cases for Mr. Deus?
No, Your Honor.
It's good to see you, counsel. Have a great one.
Next in person, Counsel Oscar Peña, page 3, number 8.
This is the estate of Jose A. Montemayor III, cause number 2025 PB 714L2. Court marks Mr. Peña, present in person. Good morning, sir.
Good morning, Your Honor.
Are you Marta Peña Montemayor?
I think you might be on.
Yes,
Could
yeah.
you- One more time. Are you Marta Peña Montemayor?
Yes, Your Honor.
Welcome to court, Ms. Montemayor. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present in person. Mr. Peña, what is the announcement?
Your Honor, we're here because the inventory was due today. We filed the inventory, the sworn inventory a few days ago. It should already be in the clerk's office. We are asking the court to approve it, and I would like to ask my client, Marta P. Montemayor, the independent and executrix, a few questions, if I may.
Ms. Montemayor, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. Mr. Peña, go ahead.
Could you please state your full name?
Marta Peña Montemayor.
And you are the you were named the independent executrix in your husband's will, is that correct?
Yes.
What was your husband's name?
Jose A. Montemayor.
And he died last year in 2025, correct?
Yes, sir.
And you submitted the will to probate, correct?
Yes, sir.
Okay, now you were required to provide an inventory for today, is that right?
Yes, sir.
Now, did you see the inventory that was filed on your behalf?
Yes, sir.
And did it include all of the property that belonged to your husband, Mr. Montemayor, at the time of his passing?
Yes.
Did the list of property include real estate?
Yes, sir.
And did the list of property include some royalty interests?
Yes, sir.
Okay, and was all of that property listed in the inventory that you verified?
Yes, sir.
With the values in that inventory, is it correct to say that those values were collected from the Webb County Appraisal District?
Yes, sir.
Do you have any reason to doubt those values?
No, sir.
As far as the debts that are owed to the estate, is it true that the debts owed by the estate, forgive me, the debts owed by the estate are primarily or really totally ad litem tax debts, correct?
Correct.
And all of those ad litem tax debts are listed on the inventory that you reviewed and that you signed, correct?
Yes, sir.
Okay, and are you asking the court to approve this inventory so that you can go forward resolving your late husband's affairs?
Yes, sir.
Okay, and this inventory, you were given until today to file it, and it was filed in a timely manner, is that correct?
Yes, sir.
And the signature that it bears on the verification is your signature, is that correct?
Yes, it is. Yes.
All right, and you're asking this court to approve the inventory, is that right?
Yes, sir.
Thank you. I don't have any further questions unless I missed something.
Ms. Montemayor, in your husband's case, cause number 2025 PB 714L2, the court sees that an inventory was due today. The court finds that you have filed that on July 13th. You have now testified to it. I find that it is in due form. The court hereby approves it. The orders for that approval are due to the court on or before.
It's July 27th, Tuesday.
The order approving should already be filed along with the inventory. If it is not, then I will make sure it is taken care of.
I didn't see it in the
That is
case.
correct, Your Honor. The proposed order is on file.
Can you print out a copy, please?
Yes, Your Honor.
To sign that order, Ms. Montemayor, do you have any questions for the court?
No, Your Honor, I do not.
I wish you all the best. Have a good day.
Thank you, sir. Thank you.
Any other cases for Mr. Peña?
No, Your Honor.
It's good to see you, Mr. Peña. Have a good-
Likewise, Judge, may I be excused?
Yes, sir. Have a great day.
Thank you.
Next in person, Counselor Ruben Arce, page 10, number 25.
Olga Gutierrez versus Susan San Miguel, cause number 2026, FLB 1012C3. Court marks Mr. Arce present in person. Olga Gutierrez, Susan San Miguel, if you're present, please step forward.
Good morning, Your Honor. Ruben Arce for Ms. Gutierrez, Judge.
Good morning, Mr. Arce. Speaking to the microphone and tell the court, are you Olga Gutierrez?
Yes, Your Honor.
Welcome to court, Ms. Gutierrez. Court marks you present in person. Speaking to the microphone and tell the court, are you Susan San Miguel?
Yes.
Welcome to court, Ms. San Miguel. The court marks you present in person. Ms. San Miguel, you were recently served with this case. Do you have a lawyer?
No, sir, I was served Monday night at 9 p.m.
All right.
So,
Will you be going forward today without a lawyer, or are you gonna
No.
hire a lawyer?
I respectfully ask, Your Honor, that I give some time to look for an attorney.
Mr. Arce, response?
Your Honor, I did inquire of Ms. San Miguel, Judge, and she did explain to me the same, Judge, that she was going to be possibly looking to hire an attorney.
Sure.
We did follow TRO, Judge. We're just asking that that matter be extended and we'd be given a date for temporary orders, Judge.
You're certainly entitled to talk to a lawyer, look for a lawyer, ask questions of a lawyer, and hire a lawyer if that's what you choose to do. So we'll give you another setting for the TRO that will be heard on
July the 30th at 2 p.m.
All right, so please look for a lawyer as soon as possible. That person is going to need some time to talk to you, answer your questions, advise you of your rights, and hopefully, before the hearing, reach out to Mr. Arce, ask what his client is asking, and hopefully you can reach an agreement. If you cannot, then I will make some decisions for each of you and both of you after listening to the evidence and testimony. Ms. San Miguel, do you have any? Oh, Ms. San Miguel, what is your email address?
That would be ssanmiguel47@gmail.
Spell it out, please.
SSANMIGUEL 47 @gmail.
Be on the lookout in your email address. If the court needs to send you between now and the time you hire a lawyer, if the court needs to send you any information, any notices, it'll go to that email address. Once you hire a lawyer and they file into the case and say that they represent you, then all of that communication traffic will go to them and not you. But between now and then, just keep up with your email. Similarly, if Mr. Arce needs to send you any communications, it'll go to that email address before you hire a lawyer. Mr. San Miguel, do you have any questions for the court?
No, sir, I don't have a question, but I would also like to request the court to allow me some time to retrieve some personal belongings. I left the residence of my own accord to, I guess, avoid conflict and keep the peace. But I was not asked by the court to leave. Okay.
Sure.
And when I went in, I mean, there was no damage done or anything of the sort. I had every intention of going back to retrieve all of my belongings, medications, documents. But after looking at the camera and seeing the reaction, I thought it was best to avoid any conflict. But I had to go in because that weekend, there was a death in my family and I did need some clothing to attend that funeral. But I have, unfortunately, I left with 4 pairs of jeans and, some very minimal clothing. So I would like some time to go in and retrieve documents that I might need should I need to pull out money from my retirement for a legal assistance.
So, Ms. San Miguel, so a couple of things are going on. On the one hand, you're requesting the court to reschedule everything to allow you to hire a lawyer. So everything gets moved to that date. On the other hand, you're requesting specific relief from the court, which I can't do at this point because you're requesting additional time. And I've now reset the date. What I can do is see if there's an agreement that I can help you reach on the record. For example, Ms. San Miguel, what specific items are you requesting to retrieve?
And Judge, if I may, Your Honor, I did attempt to speak to Ms. San Miguel, Judge, and she was very reluctant to speak to me. I explained to her that I represented Ms. Gutierrez, and she said, like, was reluctant to speak to me, Judge. She did explain to me about those items, Judge, and she said that I'm gonna hire an attorney. So she was very reluctant to, and I attempted to.
What is
confer
the
with her,
answer
Judge.
to her question?
Judge, basically, Your Honor, we would just ask that until she hired an attorney, then we would make.
I still don't have an answer to my question. What do you think the answer is?
Judge, in reference to what, Your Honor?
Right. Ms. San Miguel, what items are you requesting to retrieve?
I need important documents should I need
Tell me specifically, what is it you're requesting?
retirement documents. And of course, clothing and medication that was left behind.
What is the purpose of the retirement document retrieval and the necessity for you to have that before July the 30th?
I need to contact them to borrow the money to pay for the attorney. I would need to pull out money to pay for an attorney.
Where do you work?
I'm not currently right now, I'm only working part-time as a provider for my mother. But this is retirement money from a previous job with the state.
And the state doesn't have that information?
Yes, but I need the account number.
Mr. Arce, knowing that the request is now knowing that the request is for retirement documents, clothing, and medication, is there any agreement as to a possible retrieval before July the 30th?
If I could confer, Judge.
Judge, as
Give me 1
I'm
second.
sorry.
Judge, if she could provide us just with a list of clothing, Judge, other than that, I mean, there's no issue with.
Just the time?
there's no issue with her picking up personal documents, Judge. As far as if she's claiming that there's retirement documents or things related to that, there's no issue with that. Outside of that, Your Honor, we would just like to see exactly what she's requesting, because it could be part of the community estate, Judge.
Well, sure. And I guess the bigger question, Mr. And I don't know anything about this case or these folks, but the court heard, not under oath, but Ms. San Miguel testifies to or say on the record about some video and some concern. Mr. Arce, what do you believe would one, do you have any, knowing what you know about the case, do you have any concerns about any safety, and what could the parties agree to that the court could order by agreement that would cause this exchange to be peaceable?
Judge, if she could just provide us with a time certain, Judge, possibly, okay, this Saturday. This Saturday, Judge, let's say at 12 o'clock, she can pick up the documents. Judge, I know that last time she was present, for some reason, police were called, and we just don't want it to become an issue, Your Honor.
The police were called, Judge, to keep the peace. That was the only reason, just to keep the peace.
And did you call or did Ms.
Yes.
Gutierrez call?
No, I called. Ms. Gutierrez was not present. That's why I called. Ms. Gutierrez was not present.
And did the police in fact arrive?
Yes, they were there.
Were there any disagreements or discord?
The police requested that her sister sit down and stay in the.
My question is, were there any disagreements or discord?
No.
Was it peaceful?
Yes.
Okay.
Mhm.
So why don't you do this? I can't order this, but it sounds like based on, and none of this is testimony because you're not under oath, but at least I think both of you are nodding in agreement as to those set of facts. So given those set of facts, let me ask you this, Ms. San Miguel, it sounds like you can agree to retrieve your retirement documents, clothing, and medications Saturday at noon, so long as you call law enforcement to have them present to make sure that the exchange is peaceful. Is that your agreement?
Yes.
Ms. Gutierrez, it sounds like Ms. San Miguel can agree to retrieve only retirement documents, her clothing, and her medication Saturday at noon, so long as she calls law enforcement and they arrive prior to her retrieval. Is that something you agree to?
Yes, Your Honor.
There it is.
Absolutely.
There is an agreement stated on the record, and it is enforceable. So then come back on July the 30th at 2 p.m. and tell the court that the retrieval went well, everything was peaceful. And Ms. San Miguel, as soon as you hire someone, let them know that they should reach out to Mr. Arce so that the lawyers can talk.
Yes, of course.
Ms. San Miguel, do you have any questions for the court?
No.
Ms. Gutierrez, do you have any questions?
Thank you, Your Honor.
Mr. Arce, anything else on this case?
No, Your Honor.
Mr. Arce, it's always good to see you. Have a great day. Ms. Gutierrez, Ms. San Miguel, I wish you both very well. Have a good day.
Your Honor, that's all I have. My big shoes.
Yes, sir.
Have a good afternoon, Judge.
You too.
First online, Counsel Joe Benavides.
Good morning, Your Honor.
Mr. Benavides, what page and case are you on?
It is in the estate of Hector Jose Factor, PB 7902, 2025. I'm not sure what page it is, Your Honor.
I don't have that on the court's docket. Give me a cause number, please.
Cause number 2025 PB 70000079L2.
Correct, Your Honor. The date wasn't open.
Court calls that case, cause number 2025 PB 77902, in the matter of the estate of Hector Factor. Court marks Mr. Joe Benavides present by video conference. Counsel, what is the announcement?
Thank you, Your Honor. Yes, I'm here on behalf of my client, independent executress, Ms. Zulema Reyes Soto. The inventory was due today, Your Honor. At least it was our understanding that it was. And we are requesting a short continuance. We received 3 or 4, I think around 3 medical claims just 2 days ago. And we wanted to run those by our client and have her come in and sign the inventory and list of claims so that we can submit it for the court.
Without objection, it is so ordered. I just want to confirm, is anybody else present on the Hector Factor case? Court finds no other persons are present. This inventory will be due on or before.
How much time? Since it would be the third inventory hearing then.
We need a week at most.
It was 2 to 4.
August 18th at 2 p.m.
All right. I will call the case on August 18th at 2. Any other cases for Mr. Benavides?
No.
Have a great day, Mr. Benavides. Good to see you.
Likewise, Your Honor.
Next online is Council Brenda Anderson, page 3, number 7.
The estate of Jesus Galvan, cause number 2025 PB470L2. Good morning, Ms. Anderson.
Good morning, Your Honor.
Court martial present participating by video conference. Belinda Galvan, are you present?
I don't think so, Judge.
Court finds Ms. Galvan not present. Counsel, what is the announcement?
Your Honor, we're set for inventory due. We did file it. However, I just realized this morning that we did not publish the notice to the creditors. So we will be doing that. And so maybe in an abundance of caution, have this inventory reset for another 60 days. And then just to make sure, my client doesn't believe there's any claims, but we are required to publish to creditors.
It's an honest and good request. We'll take it. Ms. Rodriguez, give us a setting in 60 days, please.
September 15th at 2 p.m.
So ordered. Any other cases for Ms. Anderson?
No, Your Honor.
It's good to see you, counsel. Have a great Thursday.
Thank you. You too, Judge. Thank you.
Next online, Council Claudia Lanese Garcia, page 1, number 1.
This is the estate of Alejandro Evaristo Villarreal III, cause number 2021 PB555L2. Court marks Ms. Garcia present by video conference. Mr. Juan Hernandez Francisco Tamés, are you present?
No, sir. I think it's just myself and Mr. Garcia.
Guillermo Garcia here for one of the heirs, Judge.
Court marks Mr. Guillermo Garcia also present and participating by video conference. Are there any other parties, witnesses, or any other persons present on this case? Court
No, sir.
finds no other persons present. Counsel, what is the announcement?
Your Honor, if you recall, I had to advise the court that my client, the first administrator, was non-compos mentis, and Mr. Tamés filed an application for a successor administrator. Today's hearing was for entry of judgment, and I recall seeing the orders for the new administrator, the oath, bond, everything having been filed, Judge. So technically, I no longer have a client in this case because I no longer represent the administrator. But I do believe that the orders have been filed. And if they haven't been signed, I just ask that they've been signed because we've notified banks, we've notified other persons that Fernando Villarreal is the new administrator, and Mr. Tamés is going to be representing him in that capacity.
Mr. Garcia?
No objections, Judge. I think it's correct what Ms. Lanese explained.
Well taken. Cause number 2021 PB555L2. We're set for entry of judgment on a joint application for the appointment of a successor dependent administrator. The orders have been filed. They are signed. The court is tendering the original to the clerk's office. Just one other point. First point, inventory is scheduled on this case and it's due September 17th at 2 p.m.
There was an inventory filed years ago. This was for successor administrator.
Understood.
And so the parties are pretty much at the conclusion. The frustration here is that my client just fell ill, had a steep decline, and couldn't finish his duties as administrator, which is really going to be to sign documents to partition and distribute the assets, because the parties have come into a mediated settlement agreement.
Understood. I guess the only other point, Ms. Garcia, if there's any other relief that is requested by the court that requires notice to be sent out, you will continue to receive notice unless you filed some sort of
Yes, I'm
notice
gonna,
of-
I need to file my last request for payment and my motion to be excused.
All right.
But
Pending
I
that,
don't have a client in this case anymore. But
pending
I will
that,
get that filed, Judge.
we'll stand at ease on this case until that's filed. Ms. Garcia, anything
Yes.
else on this case?
No, sir.
Mr. Garcia,
Nothing further.
any other cases for either council?
None for Council Garcia, but to clarify, we take it off the docket on 9/17.
Yes.
Thank you, Your Honor.
No more cases for which Council Garcia?
Council Guillermo.
Mr. Garcia, good to see you. Have a great Thursday.
Thank you, likewise.
Page 1, number 2.
This is in the matter of Paul Herman Young Jr., cause number 2022, PB 690L2. Court marks Ms. Garcia, present by video conference. Are you Kelly Morganson?
Yes, yes, Your Honor.
Welcome to court. The court marks you present by video conference. Are you Greg Allen Morganson?
Yes.
Welcome to court. The court marks you both present and participating by video conference. As you can see and hear from your device, your lawyer is present in and participating by video conference as well. Ms. Garcia, what is the announcement?
Your Honor, as the court is well aware, the ward passed away in January of this year. An estate has already been established. Executors have already been appointed, and an administration has already been in effect. So we're trying to close the guardianship and transfer everything over to the estate. And so they're just the last housekeeping matters, the first of which is the application for compensation of the guardian of the person, and this is for Miss Kelly Morganson, Judge. The accounting, she filed her annual report of the ward in January, Judge, and he passed away shortly after. After we finalized the account of the ward, the annual account, Mr. Morganson and Miss Morganson were entitled to compensation. And so the final account covered the compensation for Mr. Morganson. That has already been approved, Judge. But what has not been approved is Miss Morganson, her request for compensation as guardian of the person during the last accounting year, which was 2025 to 2026, Judge. And in my motion, I spell that out. And the total amount that she is entitled to receive as compensation is $6,692.43. And that is the reporting period through January 18th, 2025 through January 17th, 2026. So we ask that the court approve that, and then the executors of the estate can go ahead and pay that to her.
Cause number 2022, PB 690L2. The court has received, reviewed, and considered the application for compensation and guardianship of the person. And the court finds that the services rendered in the amount of $6,692.43 is for the care and assistance given to the ward in compliance with the Texas Estates Code. The court sees that it is a good due and owing request. The court hereby approves the request and has signed an order to that effect.
Thank you, Judge. Next, I do have a final application for payment of attorney's fees here. And this is the last invoice that covers the last reporting period for the work that it was done for the accounts, and then the documents necessary to close this guardianship, Judge. And that amount, it's verified in the amount of $11,867.50. I submit to the court, I provided an affidavit with regard to the reasonableness and necessity of those fees, Judge, and I ask that they get approved as well.
Cause number 2022 PB 690L2, the court finds that Ms. Lanesha Garcia has provided legal services. In this case, the court has and hereby takes judicial notice of the final application for payment of attorney's fees, including the Exhibit A, which is a detailed billing statement in this case, and Exhibit B, which is her enclosed affidavit. The court finds that Ms. Lanesha Garcia is a duly licensed attorney in the state of Texas. The court finds that she has provided legal services in this case. She has been licensed since 1995. Personally familiar with the amount of services in this case, the court finds, having taken notice of Exhibits A and B, court finds that reasonable and necessary fees in this case with regard to this matter and complexity thereof is $11,867.50. The court has received an order to that effect, has signed it, and tendering the original signed copy to the clerk's office.
Thank you.
Anything
And
else, Judy?
finally, Judge, yes, finally, the court had already excused Miss Morganson from her duties as guardian of the person. We were just waiting to excuse Mr. Morganson as guardian of the estate and finally close and discharge Mr. Morganson from his duties as well as the bond judge. So the court has approved the final account by the guardian of the estate, Mr. Morganson. So at this time, having taken care of the remaining issues in the guardianship, I ask that the court consider and approve the application to close the estate and to discharge Mr. Morganson and his surety bond and finally finish this matter and let the estate go forward.
For all the reasons stated on the record, the court finds that is a good request and well taken. Cause number 2022 PB 690L2. The application to close the estate and discharge the guardian of the estate is hereby well taken and approved. Is there a proposed order to that effect?
Yes, Your Honor.
Got it. The court has signed that order. This case is now closed. And this matter, I guess, closes out, but the rest proceeds as a probate matter. Anything else on this case, Ms. Garcia?
No, sir, I would just like to say that Mr. and Mrs. Morganson have been ideal guardians, Judge, and I thank them for their service.
Ms. Morganson, Mr. Morganson, you continue to have the court's condolences, but the court does appreciate all the services, love, and care that you have provided for Mr. Young.
Thank you.
Remind the court, Ms. Garcia, the probate matter is in County 2, is it not?
Yes, and I did check. Mr. Sigifredo Perez is representing the executors, and the court set the guardianship matters for today because it was the inventory deadline, Judge. And I did verify, I did check online, and an affidavit in lieu of inventory has been filed weeks ago, Judge.
All right, Ms. Morganson, Mr. Morganson, I wish you both very well.
Thank you.
Judge.
Thank you, Judge. Thank you, guys.
Any other cases for Ms. Garcia?
Page 4, number 11 is guardian invited.
This is Dominga de Hernandez, VA and VY versus Alberto Perez, Cindy Perez, cause number 2026 CBM4L2. Court marks Ms. Garcia present by video conference. Sergio Lozano, Christian Ramon. Any other lawyers present?
Your Honor, if I may, there was an agreed motion for continuance filed by Mr. Lozano.
Yes, sir. That's correct.
Any objection?
No, sir. It was all agreed to.
Court has received, reviewed, and considered that written motion. It is well taken and agreed to by all parties or counsel in the case. Ms. Rodriguez, give us a setting in 60 days, please.
September 17th at 2 p.m.
So ordered. Any other cases for Ms. Garcia?
No, Your Honor.
It's good to see you, counsel. Have a great Thursday.
Judge.
Next online is Counsel Ron Rodriguez. Don't see his name on the docket.
Mr. Rodriguez, what page and case are you here for?
Good morning, Judge. I'm here on 2016 PB 40080 L2. This is the senior estate. I have on my calendar that you from the bench, and it's also on the docket sheet, had set us for a final pretrial for today at 9. And so my client was here, Harold DeValley Jr. was here, and I'm here. And I just want to make sure there's no hearing. I mean, I don't see opposing counsel, so obviously we can't go forward on anything, but I just want to make sure that I'm present and Your Honor knows that I'm
I
here.
certainly appreciate the diligence, Mr. Rodriguez. It's not on my docket, but perhaps there is a miscalendering or error on our part. Let me ask our court coordinator and or clerk to confirm.
I see that there was just a deadline of August the 7th for mediation. That was announced on June the 9th.
If you see on the docket sheet, there was an announcement earlier, let me look for it, with a pretrial today and a trial for August the 4th. Let me get that for you. I'll get you the exact date. I just want to make sure.
And I guess as you do, Mr. Rodriguez, let me
Here it is.
ask.
Back
Let
on
me
March
ask.
19th, Your Honor.
Yeah.
Being that based on the last hearing, those dates were canceled or moved.
That may be it. It may not have hit the docket because if there was a recalendering either in person or on the record, then that would have eliminated any previous settings. It's just not, there isn't anything set for today. Is there anything you would like to put on the record on this matter, Mr. Rodriguez?
Well, Judge, I just want to, on March 19th, Your Honor, set this case for August the 4th as well, for trial. And I just want to make sure there's not a setting on that day because I don't want to come back here and that happens again. So I just want to make sure there's nothing set for August the 4th at 2 p.m.
May I ask our coordinator, is there anything set for August the 4th?
No, Your Honor.
All right.
When is the next hearing that the court has set for this case? I just want to make sure I have that.
I don't have, other than the deadline, I don't have that. I will go back.
Understood.
Review and we will go ahead and send the setting.
All right. Thank you, Judge. Obviously, the opposing counsel isn't here. We can't talk about any substance, but appreciate the calendaring direction. So I guess.
You thought we were setting your here, so I certainly appreciate that. Thank you, Mr. Rodriguez.
And for the record, my client was here too, Judge, and I excused him. All right.
Okay.
Thank you, Judge. That's all I have. Be excused for today.
Have a good day.
Thank you.
Next line is counsel. Hannah Hubert.
Good morning, Your Honor.
Good morning, Ms. Hubert. What page and case are you here on?
Your Honor, I'm not sure what number I am on the docket, but I'm here on the Valley Alto Produce versus Pure Fields LLC.
Page 8, case 19, 2026 CVI 786C3. The Alto Produce SA, the CV versus Pure Fields LLC. Remind the court, Ms. Hubert, you're here on behalf of plaintiff or defendant?
I'm here on behalf of Plaintiff Valley Alto Produce, Your Honor.
Ms. Hubert, welcome to court. The court marks you present. You're participating by video conference. Ms. I see there's a device titled Pure Fields LLC. Would you tell me your name, please?
Yes, Judge. Good morning. My name is Stephanie Barbarena.
Ms. Barbarena, and what is your relationship to the defendant?
I am the owner.
Court marks you present and participating by video conference. This is a calendar call and a motion for default judgment. Ms. Hubert, what is the announcement?
Yes, Your Honor. We properly served defendant and they failed to timely file an answer or any sort of appearance. So we went ahead and filed our motion for default judgment. This is the first we're hearing from Miss Stephanie. And as of today, I'm not aware of any answer or appearance that has been filed.
Well, so Ms. Barbarena, the owner of defendant, is present. Based on that, what is your announcement and request, Ms. Hubert?
We were prepared to move forward with the motion for default judgment. Now, since Purefields has appeared, I'm not sure if the court would be willing to let us move forward that motion for default judgment or give them additional time to answer.
Ms. Barbarena, the defendant, is it a business organization?
Yes, it's an LLC.
Hmm. And what, if anything, would you like to tell the court, Ms. Barbarena?
Okay, I was my accountant notified me of this court hearing a couple of days ago. That's why I was not able to answer. Purefields, we are a small business. We acknowledge the debts to Vallalto Produce for 37,000. 37,000 for two invoices, and I would like to know if I can have a chance to negotiate the balance here with you, Judge. Not the balance, the payments. I'm sorry. We acknowledge we respectfully request the opportunity to resolve this through a structured payment plan rather than a default judgment, if that is possible.
Well, I tell you what, Ms. Barbarena, tell the court your email address.
It's Purefields LLC at gmail.com.
I tell you what I'm going to do, Ms. Barbarena and Ms. Hubert. I'm going to do several things. First, I'm going to set this for a calendar call in 30 to 45 days. Ms. Rodriguez?
That would be September 15th at 2 p.m.
And I'm going to schedule this also for that default judgment. Ms. Hubert, please correspond with Ms. Barbarena at the email address provided. Several things are going on that you should know of, Ms. Barbarena. Since the defendant, Purefields LLC, is a business organization in the state of Texas, it must be represented by a Texas lawyer. And I guess I should ask the question, I shouldn't presume anything, but Ms. Barbarena, are you licensed to practice law in the state of Texas?
No, sir.
Right. So if any person would like to officially be heard on this case on behalf of Purefields LLC, only a person with a law license licensed by the state of Texas can do so on behalf of Purefields. So if there's no answer on file, then the plaintiff, in this case, Vallarto Produce, could go forward and take a default judgment. I think in the interest of justice, if I did that, Ms. Hubert, what would happen is you'd probably be granted an order that may be collectible or may not. It sounds like if the court grants this time, perhaps a structured payment plan that is enforceable and collectible, given Ms. Barbara's statements here today, would likely be in the interest of justice. So let me give you some time to do that. If none of that works out, then Ms. Barbarena, you need to hire a lawyer on behalf of Purefields, and if not, the court will consider that default judgment. Do you have any questions for the court, Ms. Barbarena?
Is there any chance that we can resolve this with Vallalto Produce to make a payment and resolve this matter?
Well, that's exactly what I'm asking that you do before September the 15th.
Oh, yes. I will. Can I contact Vallalto Produce, Ms. Hannah?
Yeah, I will get in touch with you. If you would give me your phone number, I'll give you a call right as soon as we get off of here and we can go from there.
Yes, ma'am. It's 956 225 8766.
Okay, thank you, Your Honor. I will be in touch with Ms. Stephanie, and we will be prepared for this, the 15th of September.
All right, if there's an agreement before then, just file it into the case. I'd be happy to sign off on it. If there isn't an agreement, I'll hear that default. You know what, I'm gonna give you one more setting, just in case, for whatever reason, if there's no agreement and for whatever reason, there's an answer on file on that date, you're still gonna require a final hearing date. So the default is set for September the 15th, but the final hearing date is set for October.
October the 6th at 2 p.m.
Any objections to this, Ms. Hubert?
No, Your Honor.
Any objections, Ms. Barbarena?
No, Your Honor.
All right, so you have until September the 15th. I wish both parties very well. Everyone, have a good day.
Thank
Your
you.
Honor. Thank you. Bye-bye.
Next
Thank
on
you.
my
Bye.
Council Travis Miller, page 4, number 10.
This is Laredo Housing Authority versus Mireya Pintor, cause number 2026 CVD 1L2. I'm sorry, who was the lawyer on the case?
Travis Miller, Your Honor.
Mr. Miller, are you present?
Your Honor, if I may, Guadalupe Canales, on behalf of defendant, did file motion for continuance.
Ms. Canales, are you present?
Yes, Your Honor, I'm present on behalf of my client, Ms.
Are you
Mireya.
able to turn on your video?
Yes. I don't know why I look upside down, but I do.
Welcome to court, Ms. Canales. The court marks you present and participating by video conference. Mireya Pintor, are you present?
Device.
Yes.
Ms. Pintor, I need you to unmute your device and start your video, please.
Yes.
Are you Mireya Pintor?
I think she
Yes,
needs a translator,
yes.
Your Honor.
Welcome to court, Ms. Pintor. The court marks you present. You're participating by video conference. There is a request for continuance.
Admitting Council Miller. I think you got disconnected.
Judge, I apologize.
Welcome to court, Mr. Miller. The court marks you present. You're participating by video conference. Mr. Miller, court called this case at 10:44. Court heard Ms. Canales. She's present by video conference. She filed a written motion for continuance. Her client, Ms. Mireya Pintor, is also present and participating by video conference. Mr. Miller, your thoughts, comments, any objections to the request for continuance?
Well, first, Judge, we also have our client representative. I believe it's Ms. Raquel Aguilar on Zoom as well. She may be in the waiting room, so we would ask that she be let in. I apologize for having to appear via phone. I'm here in San Antonio, Texas, and we're getting hit with a lot of rain, which is causing a lot of our internet, I think, here at the courthouse to be a bit wonky.
Tell me the name of the authorized representative for your client.
I believe it would be Raquel Aguilar for Laredo Housing Authority, Judge.
Ms. Aguilar, are you present?
Not identified yet.
So the court finds that she is not present in person. She's not present by video conference, neither in the actual virtual well or the waiting room. Mr. Miller, go ahead.
Well, Judge, if I don't have a client, that's going to change my announcement, obviously. We would object to the motion for continuance, or at least I was planning on objecting to the motion for continuance. However, Judge, if we can agree to a very short 2-week reset, I would be more than happy to agree to that continuance. The reason, Your Honor, that we would object to the continuance is there are several statements in the continuance request that I believe are somewhat disingenuous, Your Honor, namely that Ms. Canales previously represented Ms. Pintor at the JP court level. Ms. Pintor opted to appeal that decision. I don't know where any communication breakdown happened between Ms. Pintor and Ms. Canales, but Ms. Canales is aware of the facts of this case and is familiar with the facts of this case. Ms. Canales also, from what I understand, regularly represents tenants in eviction matters, which this is an eviction appeal for non-payment of rent. The facts are fairly simple. The other issue, Judge, here with the motion for continuance is it states that one, Ms. Pintor is currently living or residing in Wisconsin, and that she needs time to come back to get proof of payments that she allegedly made. The issue there is twofold, Judge. One, if she's not living in the unit, there is certainly unauthorized occupants in the unit, which causes a great concern to my client. And two, Your Honor, while I understand that Ms. Pintor has been making payments regularly into the court registry, none of those payments, with the exception of the July 2026 payment, as ordered by the court, have been in the full amount. So if you look, Judge, she's paid on January 6th, 2026, $549, January 30th, $547.
Sounds like Mr. Miller, without further going into
Understood.
authenticator or non-testimony, non-evidentiary statements. I guess that's good background, but I think both parties are actually on the same page, knowing what the court heard earlier about the next settings being in September, number one. Number two, that your client is not present. Third, Mr. Miller, is there an objection to this motion for continuance?
Well, Judge, I do object to the motion for continuance, particularly as.
Okay, then are you ready to call your first witness?
Well, Judge, my objection is just to a setting in September, not to the continuance itself, because I do not have a client here. My understanding is that the client was present in the waiting room. I don't know what the disconnect is there, and I haven't been able to get in touch with them, Judge. So as long as we can agree to a short continuance, that would be my request.
You can agree to anything that you would like, but even if the lawyers agree or the parties agree, the court still needs to approve that agreement. So I tell you what, the court is going to give the very next available setting that doesn't have a lot of cases, because it sounds like this is going to require a rather lengthy evidentiary hearing.
I disagree. And I apologize for the interruption, Judge. I have a bit of a delay on my end.
That being the case, Ms. Rodriguez, give us the next setting that would allow the court to hear a contested matter. I'm looking for August or September.
Yes, Your Honor, I just need, I need to look at the cases that are set for the August 18th has.
I'll set it for that day unless,
August 18th at 2 p.m.
all right, so several things with regard to this setting. Mr. Miller, Ms. Canales, the court is going to order that that setting be in person. So all lawyers, all clients, all witnesses, all persons, number one, must be in person. The court finds that this setting would be in the interest of justice, given that one side is requesting additional time and the other side doesn't have a witness present. August the 18th at 2. Thoughts, comments, questions, or objections? Mr. Miller?
Yes, Judge. Unfortunately, I believe that an in-person setting, and I think I have to backtrack a little bit. So, one, Judge, I don't believe this is going to be a very long or evidence-heavy matter. This is a non-payment of rent eviction. There's a lease, a ledger, and a notice to vacate. 3 documents. So I do not believe that it is necessary for an extended section of the court's time. But I understand that the court is setting it for August the 18th, and we will be present. I would ask, Judge, if we can continue to make this either a Zoom or hybrid hearing so that one, Ms. Pintor, who is apparently located in Wisconsin, can be present without any prejudice to Ms. Pintor, and two, so that my client does not incur additional attorney's fees, which they have already incurred because this is our second setting on this matter, Judge. by having my office drive to Laredo and back for what will be a 20 to 30-minute hearing. So I would ask that the court
Before the
allow
court,
for remote proceedings.
before the court makes a final decision, let me hear your thoughts, Ms. Canales, as to a virtual or in-person setting. Ms. Canales.
My client has no problem being in Laredo. I'd like to correct the opposing counsel. My client has not relocated to Missouri or to Wisconsin. She goes back and forth. She migrates to follow work, and she will be here. I would oppose a remote trial. This case is not a very simple case. The Laredo Housing Authority has committed several mistakes in bringing about this eviction proceeding, and my client also has been having problems getting some of the documents from the plaintiff, and that's why we need this time, the 30 days. And my client has no problem being present, and we object to a remote trial.
All right, this is what the court is going to do in this situation. You're set for a final hearing on August the 18th at 2. Ms. Rodriguez, I am going to also order and set a final pretrial hearing in July. That setting is on.
May we set it on a civil family docket then?
Yes.
July the 30th at 2.
This is the deadline that the court is going to order for all evidence uploading to Case Center. I'm going to modify the 24-hour and I'm going to do it on July the 30th. So all evidence that will be presented to the court must be uploaded to Case Center before July 30th at 2. If there are any pretrial housekeeping, and that final pretrial hearing can and will be by video conference if anybody would like to do so. You're welcome to come in person, but that final pretrial hearing on July the 30th at 2 can be by video conference. The final hearing on August 18th at 2 is in person, and the court makes certain findings on the record for this reason. In this case, the court called this case at 10:44. Mr. Miller was not present, but was, I think, inadvertently outside of the
I got kicked out of the Zoom.
and then was readmitted. Ms. Aguilar, on behalf of plaintiff, was present, is no longer present. Ms. Pintor, the defendant, was present by video conference, had trouble with her audio. Ms. Guadalupe Canales, lawyer for defendant, is sideways and with a virtual background that has nothing to do with this case. So no one here, I find, should be by video conference on the date of the final hearing. 0 persons. All right. Be here in person on August 18th at 2, and a final pretrial hearing by video conference on July the 30th at 2. Anything else on this case, Mr. Miller?
I'm looking here at my calendar, Judge, because I need to make sure that I can take an entire afternoon off to be there at 2 o'clock in the afternoon to travel back and forth. Please bear with me, and I need to make sure that we don't have anything at that time. We will be present, Judge, although we will be asking for travel costs and expenses for that hearing. So hopefully that will get us to a resolution quickly with Ms. Pintor.
Well, let me do one other thing in that event, Mr. Miller, Ms. Canales, the court orders that you informally mediate and to try an informal settlement conference between the two of you before July the 30th. Now with this new information that Mr. Miller will be asking for cost assessed if his client prevails. Ms. Canales, anything to add to the record on this case?
No, Your Honor, that's fine. I'll reach out to the plaintiff regarding possible settlement.
First question that the court will ask on July the 30th is whether counsel has in fact conferred, and what are the results, if any, that can be announced regarding that conference. I wish both parties very well. Have a great day.
Thank you, Your Honor.
Next online, Counsel Henry Falcon, page 3, number 6.
Ms. Canales?
Elsa Alicia Huitrón, Roberto Huitrón, Vicente Amador Ramírez, Oscar Joel Amador, Elim Hernandez. Cause number 2025 CVM 17L2. Good morning, Mr. Falcon.
Good morning, Your Honor.
Court martial present by video conference. Are you Georgina del Valle?
I am, Your Honor. Good morning. I am counsel for Elim Hernandez for the record.
Welcome to court. The court marks you both present and participating by video conference. Are any parties present?
No, Your Honor. Just
no parties are present. Counsel, what is the announcement?
Judge, we actually provided a notice of settlement with the court, so we are able to announce that we are not moving forward trial and this matter has been resolved.
That is correct, Judge.
Congratulations to the parties on successfully resolving their matter. Let me set this for entry of judgment. You're scheduled for a jury selection conference August the 18th. Is a month sufficient time to either file a non-suit or a judgment of some sort?
I believe so. Yes, Your Honor.
All right, then the court will set this for entry of judgment on August the 18th and eliminating all other settings. Any other cases for Mr. Falcon or Ms. Del Valle?
No, Your Honor.
No, Your Honor.
It's good to see you both. Congratulations.
Thank you, Your
Thank
Honor.
you. Likewise.
May we
Court
be
will
excused?
stand at, yes, have a great
Thank you,
day.
Your Honor. You too.
Court will stand at ease momentarily.
Court is at ease.
That they also find it. So we have a I just found mention to you from there. Well, the other one can after you. They know it. Like just keep one and just one weekend. What did you say?
Court is back in session and we are on the record. This is the probate and civil docket for Thursday, July 16th, 2026. The time is now 11:09. Ms. Rodriguez, would you call the next case, please?
Next attorney online, Counsel Alan Schenkel, page 7, number 16.
Only Leasing Corporation versus Triple RRR Carriers, Inc. and Blanca L. Rodriguez, cause number 2025 CVK 002270C3. Good morning, Mr. Schenkel.
Good morning, Your Honor.
Court martial present, you're participating by video conference. Are any parties present? Court finds no other persons are present. Counsel, what is the announcement?
We filed a motion for default judgment on June the 12th. And then we filed an amendment or a supplement to the motion for default because the corporate defendant filed bankruptcy. So the motion and the supplement only now deal with the individual Blanca L. Rodriguez. She was served on April the 29th of this year. She has not filed an answer or made any appearance. The citation of the officer should be on file with the court. And the matter that before you is a liquidated debt. This pertains to a equipment finance agreement, which is attached to the motion with the affidavit of plaintiff's representative. There's also on file a document entitled, a payoff quotation, which explains how the debt was calculated. And we're asking the court to enter judgment for the amount of $86,303.36 plus interest, court costs. We've attached an affidavit for legal fees. It's been about 10 hours at $325 an hour for $3,250.
In cause number 2025 CVK 2277C3, the court at this time finds that it has jurisdiction over this matter. The court takes judicial notice that both defendants were served with process on the 7th day of May 2026. The court, having taken judicial notice in the entire case file, sees that a motion for default judgment has in fact been filed, and a supplement thereto was filed on June the 15th. The court sees that there is an affidavit in support of the default judgment. The court sees that there is an amount claimed of $86,303.36, a liquidated amount. The court also takes judicial notice of the affidavit for attorney's fees in the amount of $3,250, given counsel's education experience, hourly rate. The court finds that that amount is reasonable and necessary given that verified affidavit for attorney's fees. The court also takes notice of the non-military affidavit on file and the certificate of last known address. For all of these reasons, having said all of that and taking judicial notice of the entire case file, finds that Ponley Leasing Corporation is entitled to a default judgment against defendant Blanca L. Rodriguez only in the amount of $86,303.36 at a rate of prejudgment interest of 5% from April 15, 2025 until today, July 16, 2026. Attorney's fees in the amount of
I see I made a mistake there. I see I made a mistake on the judgment.
Yeah. So I'm going to go with the affidavit because that's what's verified. I find the court finds that the attorney's fees in the amount of $3,250 is reasonable and necessary. Post-judgment interest in the amount of 5% and court cost. These are the orders to the court. The orders are due to the court honor before
July 27th.
All right, so just file the amended default order with only Blanca Rodriguez and the true and correct amount of attorney's fees of $3,250.
Okay, so I did file an amended or a new default judgment on June the 15th when I filed the supplement, but the attorney's fees are inaccurate, so the court wants me just to refile a new one. Okay, and also just want to make sure.
If I can scratch it out, but it's gonna look, it ain't gonna look right. So just
No, that's fine. And I just want to make sure the court is aware also in this judgment, we did put a non-suit of the other defendant, triple RRR carriers. So that would make it a final judgment.
Was there a proposed order on the non-suit filed?
No, but I put it in the judgment that I was also asking, excuse me, on the second page of the judgment of the supplement that I filed to dismiss against triple R without prejudice.
I see that. Please leave that language in there. So when I sign it, I'll indicate to the clerk's office that this case will be disposed at that point.
Okay, and I'll get a new one on file today.
All right. Any other cases for counsel?
No, Your Honor.
Have a great day.
Thank you, Your Honor. Appreciate it. Have a good day.
You too.
Next online, Counsel Marcel Knotson, page 7, number 18.
A&S Electric LLC versus Pinnacle Construction, Inc., cause number 2026 CV 8702C3. Good morning, Mr. Knotson.
Good morning, Judge. How you doing?
Very good. The court marks you present and participating by video conference. Any other parties, lawyers, witnesses present?
Not present or identified.
Court finds no other persons are present. Mr. Knotson?
Yes, Judge. We had filed a request for default judgment for your consideration, and I apologize. I got my code here if you want me to put it on.
I guess I must have missed it, but if I did, I apologize. Let me ask the clerk's office. Is there a service effectuated on defendant?
Let's see, there's
Court takes judicial notice that defendant will serve with process May 1st, 2026. Mr. Knotson, are you ready to go forward on this default?
Yes, Your Honor. Basically here, I'd ask the court to take judicial notice of the contents of the court's files. The court just noted they were served on May 1st. They failed to file an answer with the time allowed by law. Their answer would have been due by the end of May. And it's been on file with the court 10 days exclusive of the day of filing, the day of judgment. So pursuant to Texas Rule Civil Procedure 289, as well as the rules of court, we're requesting that the court grant a default judgment. We also filed a certificate of last known mailing address of Pinnacle. Since it's a corporation, there is no military affidavit needed. And I believe the certificate of last known address was filed on July 10th, and we have a proposed final judgment that has not been filed yet, but basically it just recites the facts that we stated. Basically we're asking the court grant on breach of contract, sworn account, quantum merit, promissory estoppel. The actual damages are 18,705. We had the 5,000 attorney's fees, cost of court or $500, and prejudgment interest. I hadn't calculated that, but it's 6.75% as of today is the prejudgment interest rate, and that would be the same for the post-judgment. And then I would just ask that any and all other relief not granted is denied. And it's a 4-page judgment. I can upload that here before noon for your review and consideration.
If let me pull up the case file because I missed the service date. Now I missed the attachments too. Give me 1 second.
And it was a verified petition, Judge. So it proves up all of these facts. you get that for me, Vanessa, please? Just
Right, in cause number 2026 CVH 702C3, the court takes judicial notice of the entire case file, including the original petition, the date of service for defendant, May 1st, 2026. Court sees and finds that there is no answer on file. Court finds that plaintiff is entitled to a default judgment against defendant. Default judgment is granted. I am going to now schedule this matter for an evidentiary hearing on damages. Give
okay,
us
Judge.
a setting, Ms. Rodriguez?
How much time? are
Whatever we have available, I would assume 30 to 45.
we- September 15th,
September 15th at
2 p.m.
so ordered. Any other cases for Mr. Knotson?
No, Your Honor.
Have a great day, Mr. Knotson. Good to see
Thank you,
you.
Judge. I appreciate it. You too. Have a good day. Bye-bye.
Next online is Counsel Alberto Martinez King. Do not have a.
Mr. Martinez King, what page and case are you here for?
I don't have the page number. I do have the cause number though. It's for 2014 CBF 001055C3. We're standing in for Zwicker and Associates.
H5 number 13, Your Honor.
Oh, I see. Discover Bank versus Manuela Garcia, cause number 2014 CVF 1055C3. Court marks Mr. Alberto Martinez King present and participating by video conference. Manuela Garcia, are you present?
Identify.
Court finds defendant not present. Mr. Martinez King, what is the announcement?
So this is for an application to revive judgment on this. It's been 10 years, a little over 10 years since the judgment was originally had. It went dormant, and so we're trying to revive it.
Court takes judicial notice in the entire case file, including the application for the writ, the affidavit of attorney in support of the application to revive the judgment thereof, and the default judgment taken on April 8th, 2015. The court finds that plaintiff is entitled to the relief it is requesting. It is granted. Court is signing an order to that effect. And tendering that original order to the clerk's office. Any other cases for Mr. Martinez King? Have a great day, counsel.
Thank you, Judge.
All identified individuals in virtual physical courtroom have been called.
You can call the rest of the docket as the cases appear on the docket. Page 2, case 4, the estate of Andres Segovia, cause number 2024 PB 489L2. Juan Jose Garcia, are you present?
Present.
This is a second setting for an inventory. Is an inventory on file?
No, Your Honor.
This case is set for show cause on
September 17th at 2 p.m.
send notice, please. Page 2, case 5, the estate of Fabian Garcia, cause number 2024 PB 779L2. Luis Antonio Figueroa, are you present?
Not present.
Court finds Mr. Figueroa not present. This is an inventory.
Same announcement, Your Honor. No inventory has been filed.
Is this a first or second setting?
Second, Your Honor.
Third setting. Give us a show cause setting on September the 17th at 2 p.m. So ordered. Ms. Rodriguez, have all cases on the probate and civil docket been called?
Yes, Your Honor.
Court will now begin the criminal law docket. Ms. Rodriguez, would you call the cases in the order of appearance of counsel, please?
First in person was Counsel Guillermo del Barrio, page 2, number 4, 5, 6, 7, 8, 9, 10.
Court, good morning. Court call 7 cases, same person. State of Texas versus Jaime Gonzalez Jr. Cause numbers are 2022 CRB 567L2, 2022 CRB 568L2, 2022 CRB 611L2, 2022 CRB 613L2, 2023 CRB 117L2, 2025 CRB 476L2, and 2025 CRB 1230L2. Court marks Mr. Del Barrio present in person. Are you Jaime Gonzalez Jr.?
Yes, I am.
Welcome to court, Mr. Gonzalez. The court marks you present and you're participating by video conference. As you can see and hear from your device, your lawyer is present in person. Who is the prosecutor?
Omar Villarreal for the state, Your Honor.
Welcome to court, Mr. Villarreal. The court marks you present in person. Mr. Del Barrio, what is the announcement on the 7 cases?
Your Honor, we have an agreement on, well, on all of them, Your Honor. You, Mr. Gonzalez, will be pleading to 3 cases, and that will account for all 7 cases in this case, Your Honor, in this matter. And Your Honor, just for the record, Mr. Gonzalez is appearing by Zoom based on the fact that he does reside in Austin and the weather was bad. I believe I-35 was closed, so the court graciously allowed him to appear via Zoom for today.
Mr. Gonzalez, your lawyer says you would like to enter pleas of guilty for 3 cases involving a Class B theft of property charges. Is that what you would like to do?
Yes, yes, Judge.
Is that the agreement with the state, Mr. Villarreal?
That's correct, Your Honor.
Mr. Gonzalez, I'm going to ask that you raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, I do.
You may lower your hand. Now that you're under oath, is your true and correct name Jaime Gonzalez Jr.?
Yes, it is.
Mr. Gonzalez, one more time, you're joining us live by video conference. Your lawyer is present in person. Mr. Gonzalez, have you had enough time to talk to your lawyer about your case?
Yes.
Did your lawyer explain your rights to you?
Yes, he has.
Did your lawyer explain your plea agreements to you?
Yes.
I'm going to show you on your screen a true and correct copy of your plea agreements. There are signatures on those agreements. I want you to take a look at that screen and tell the court if that is in fact your signature. Is that your signature on your plea agreements?
Yes, it is.
Did you sign your plea agreements freely and voluntarily?
Yes, I did, sir.
Did you sign them after talking to your lawyer?
Yes, yes, sir.
Are you satisfied with his legal representation?
Yes, very satisfied.
Do you understand that the maximum punishment that you're facing for these charges is up to 180 days in the Webb County Jail and up to a $2,000 fine in each of those cases?
Yes, sir.
Do you understand that your plea agreement, it's a binding contract, but it's binding only on you, your lawyer, and the prosecution. It's not binding on the court. You understand that?
Yes, sir.
Keeping all of these things in mind, Mr. Gonzalez, having spoken to your lawyer, knowing your rights and knowing the possible consequences that you're facing, in your first case, cause number 2022 CRB 567L2, how do you plead to the charge of theft of property? Do you plead guilty or do you plead not guilty?
Guilty.
In your second case, cause number 2022, pardon me, cause number 2022 CRB 568L2, how do you plead to the charge of theft of property in that case? Do you plead guilty or do you plead not guilty?
I'm guilty.
In your third case, cause number 2022 CRB 611L2, how do you plead in that case? Do you plead guilty or do you plead not guilty?
Guilty, sir.
Are you pleading guilty to these 3 charges because you are in fact guilty?
Yes.
The court accepts your plea. You've done so freely and voluntarily. And the court will hear from the state.
State would like to offer plea packets as exhibit number 1.
No objection, Your Honor.
In each of the 3 cases?
Yes, Your Honor. No objection to all three packets, Your Honor. Your Honor, I did, this is my mistake. On the plea agreement, it does show 1 year as probated for 2, but I believe it should be 180 because it is a Class B misdemeanor. So I apologize for that. But other than that, the rest of the plea packets is correct.
Any objection?
No objections, Your Honor.
Couldn't do it by law as a matter of law. Well taken. All right. State, go ahead.
Yes, Your Honor. So in exchange of a plea of guilty, Mr. Gonzalez is going to pay the court costs. He's going to complete the anti-theft class. He's going to give a $500 donation to Sacred Heart. He's going to complete 50 hours of community service with 441 credit, and he's going to run concurrent with 2022. Well, all three cases are going to run concurrent, and the following cases are going to be dismissed. 2022 CRB 613L2, 2023 CRB 117L2, 2025 CRB 476L2, and 2025 CRB L230L2. It's 1230L2.
Sorry, so it's 180 days probated for the term of 2 years.
Yes, sir.
Before the court makes a decision in your case, Mr. Gonzalez, is there anything that you would like to say?
Yes, sir. At the time when those cases, these cases that I plead guilty to, I was in the, and just lost in the darkness of addiction. A lot has happened since I came and moved to Austin. I found support, changed my ways. I'm engaged in a lot of organizations with AA and drug addiction support. I have a full job, part of a company now. I have responsibilities now. I have a great team. I'm in partnership of starting my own business. There's a lot of stuff that has changed. And I would just like to apologize for the court for my behaviors. And hopefully I'll get you grant probation on this matter.
It sounds like, Mr. Gonzalez, this is what you're saying. If this is not what you're saying, please correct me, but this is what the court is hearing. In these 3 cases, you've pled guilty, and now you are accepting responsibility, and you've noted some changes that have happened in your life, and you are indicating to the court that those changes are so significant that you're not going to repeat these actions again. Is that what you're saying?
Yes, sir. That's exactly what I'm saying.
All right. Anything else on the record, Mr. Villarreal?
Nothing from the state, Your Honor.
Mr. Del Barrio?
No, Your Honor, just asking the court to approve the.
Mr. Gonzalez, in your 3 cases, the court finds that you are in fact guilty. The court finds that you have pled freely and voluntarily. The court finds that there is sufficient information in the record to permit the meaningful exercise of sentencing discretion. The punishment in each of your cases is hereby assessed at 180 days to be served in the Webb County Jail, probated for the term of 2 years. Your court cost in 567L2 is hereby assessed at
$320.
Your court cost in 568L2 is hereby assessed at
$320.
And your court cost in cause number 611L2 is hereby assessed at
$320.
You are to make a one-time donation to Sacred Heart in the amount of $500 in 567L2 in order to perform 50 hours of community service. In that case, you're asking for a 441 credit, Mr. Gonzalez. Are you currently working?
Yes, I am.
What do you do?
I work at a distribution center for Siete Family Foods.
How long have you been doing that?
2 years since I came to Austin. It's been my only job. I've been there since I started, since I came in 2024. Yes.
The court grants you that 4-for-1 credit. These are the orders of the court, and the orders are due on or before.
August the 5th.
And the court honors and approves all of your plea agreements. So cause numbers 2022 CRB 613L2, 2023 CRB 117L2, 2025 CRB 476L2, and 2025 CRB 1230L2 are hereby dismissed.
Your Honor, if I may, I didn't think about this, but I don't know if Mr. Gonzalez can get credit for any time served or maybe the court costs or any fees that he's got to pay with regard to that. I believe it's not significant on either cases, but if it could be even one day, I believe that would have helped him in getting everything paid.
Response to that request, Mr. Villarreal?
No objections, Your Honor.
Can the court coordinator or clerk advise the court how many days could the court give credit, if any?
For each one of the cases, he has 1 day.
That's what I figured.
In each of the cases.
So he was booked on, let me just- on April 17th, 2022 for the 2022 CRB 567L2. He has 1 day. On the 2022 CRB 568L2, also 1 day. And for 2022 611, he was booked August 1st, 2022, also 1 day.
The court gives you that credit in each of your cases. Your court costs are reassessed and affirmed at $220 in each of those causes. These are the orders of the court, and the orders are due on or before August the 5th.
Thank you.
Mr. Gonzalez, do you have any questions for the court?
No, sir. Thank
I wish you well, sir. Have a good day.
you.
Your Honor, just because he's in Austin right now, will he need to be meeting with probation, I would imagine, with regards to that?
Is probation present?
Oh.
Let me ask probation, what is the best way for Mr. Gonzalez to communicate with probation into a microphone?
It would be via phone, Your Honor, unless Your Honor would allow his case to be transferred to Austin.
Mr. Del Barrio.
My understanding, they actually don't transfer the misdemeanor cases.
This is
That's
true.
That's why I didn't request it, because we always get told the same. So, and Mr. Gonzalez doesn't have a problem coming once a month. He's very responsive and very, communicates very well, so.
Let me ask probation, what is the best number and best time for Mr. Gonzalez to make that call?
It could be today at 2:30 p.m., Your Honor, at 523-4358.
I'm going to order that you call probation at 2:30 at 956-523-4358. Any questions, Mr. Gonzalez?
No, sir.
Good luck to you, sir.
Thank you.
Page 3, number 11.
State of Texas versus Roman Guzman Salvador, cause number 2025 CRB 273L2. Court marks Mr. Del Barrio present in person. Who is the prosecutor assigned to this case?
Omar Villarreal for the state, Your Honor.
Court marks you present in person, Mr. Villarreal. Roman Guzman Salvador, are you present?
He is not present, Your Honor.
Mr. Del Barrio, what is the announcement?
Your Honor, in this particular case, we have an agreement, Your Honor. It's actually a good agreement. However, my client, all his numbers have been disconnected. We tried contacting his wife and his number. They've both been disconnected. We tried with his bondsman, we tried pretrial services and have been unable to contact him. It's my understanding he's always been present, and before he was always in communication. So I think originally we were set for tomorrow. I'm expecting him to show up tomorrow. I mean, just because, I mean, he's always been present, so I have no reason to believe he wouldn't. But I don't know what else to record.
But assuming that he were present, what would the announcement be then?
We would have a PTD agreement, pretrial diversion.
All right, so let me do this. Is it the ability to communicate or the ability not to communicate with defendant in this case, is it recent or is
Recent, Your Honor, very recent. Because I believe we even came into the office originally to sign a waiver, if I'm not mistaken.
so based on all of this, and then let me make a decision and then hear if there's any response or objection from the state. The court hereby issues a capias, but this case remains on for tomorrow at 8 a.m. The court will dismiss the jurors today because that would not be right unless the state has an objection. Mr. Villarreal, any objection?
There's no objection to that. I've been trying to reach out the victim. That's the only reason we haven't dismissed the case. I just want to make sure that the victim got paid by the insurance company.
And I want to say, Your Honor, I know he had brought it or he requested it, but he confirmed. I can tell the court from what he told me, he confirmed there was an accident involved in the case, I believe, and the insurance did in fact pay. I'm pending the verification, which I believe he was going to get. So that was the only thing. But that was.
Well, it sounds like there's questions both on behalf of the prosecution and defense that aren't answerable at this time. In any event, since we are scheduled today, defendant isn't present, the KPS issues. However, right after this hearing, the court will dismiss the juror since no one here is suggesting that this will go forward to a jury trial. I will call the case at 8 a.m. If defendant is present, then you can make any further announcement. If he is not present, the KPS remains outstanding and the case moves to the inactive docket. All right. Any other cases for Mr. Del Barrio?
No, Your Honor.
We'll see you here tomorrow morning.
Thank you, Judge. Appreciate it, maybe.
Yes, sir. Have a good day.
Next in person, Counsel Sergio Martinez, page 1, number 3.
So, State of Texas versus Daniel Garza, cause number 2025 CRB 538L2. Good morning. Still morning. Good morning, Mr. Martinez. Court Martial present in person. Who is the prosecutor assigned to this case?
Omar Villarreal for the state, Your Honor.
Thank you, Mr. Villarreal. Court Martial present in person. Speaking to the microphone and to the court, are you Daniel Garza?
Yes, sir.
Welcome to court, Mr. Garza. The court martial present in person. The person to your left is your lawyer. Counsel, what is the announcement?
Judge, we have accepted a plea bargain offer from the state. We have executed the plea bargain packet. We're ready to plead him guilty now.
Mr. Martinez, this is a plea only to count 1, not to 2, 3, or 4, correct?
Dismissed, yes.
That is correct, Your Honor.
All right, Mr. Garza, your lawyer says that you would like to plead guilty to assault causing bodily injury. Is that what you would like to do?
Yes, sir.
Before we proceed, Mr. Villarreal, are there going to be any findings of family violence?
Yeah, Your Honor, that's count 1. It's an assault causing bodily injury in a family violence.
But it includes findings of family violence, correct?
Yes, sir, that's correct.
That's correct.
Judge, I admonished him to possession of a handgun and firearm.
Mr. Garza, I now need to do that on the record. We are on the record. So this is official. So I am now re-advising you, I guess is what your lawyer is saying, that if you plead guilty to this charge, you would be ineligible to possess a firearm or ammunition. Do you understand this?
Yes, sir.
Knowing that if you plead guilty, you would be ineligible to possess a firearm or ammunition, is it still your intent to plead guilty to this charge?
Yes, sir.
I'm going to ask you to raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, sir.
You may lower your hand. Now that you're under oath, Mr. Garza, is your true and correct name Daniel Garza?
Yes, Your Honor.
Mr. Garza, you're joining us live in person. The person to your left is your lawyer. Mr. Garza, have you had enough time to talk to your lawyer about your case?
Yes, sir.
Did your lawyer advise you of your rights?
Yes, sir.
Did he answer your questions?
Yes, Your Honor.
Did he advise you about your plea agreement?
Yes.
I'm going to show you on the screen a true and correct copy of your plea agreement. There's some signatures on that form. Is that your signature?
Yes, sir.
Did you sign your plea agreement freely and voluntarily?
Yes, sir.
Did you sign it after talking to your lawyer?
Yes.
Are you satisfied with your lawyer's legal representation?
Yes, sir.
Do you understand that the maximum punishment that you're facing for this charge is up to 1 year in the Webb County Jail and or up to an $8,000 fine? Excuse me, a $4,000 fine.
Yes, sir.
Do you understand that your plea agreement, it's a binding contract, but it's binding only on you, your lawyer, and the prosecution. It's not binding on the court. Do you understand this?
Yes, sir.
Do you understand that by pleading guilty, you would become ineligible to possess a firearm or ammunition?
Yes, Your Honor.
Mr. Garza, are you a U.S. citizen?
Yes, sir.
Keeping all of these things in mind, Mr. Garza, having spoken to your lawyer, knowing your rights and knowing the possible consequences that you're facing regarding punishment, fees, and inability to possess a firearm or ammunition, as to count one, assault causing bodily injury and family violence. How do you plead to that charge? Do you plead guilty or do you plead not guilty?
Guilty, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
The court accepts your plea because you've done so freely and voluntarily. The court will hear from the state, please.
State offers plea packet as a state exhibit number 1.
It's admitted without objection.
No objection.
Mr. Vieira?
Yes, Your Honor. So in exchange of a plea of guilty, the defendant will have to complete 1 year of probation with anger resolution therapy, the parenting classes, 500, the 80 hours of community service and court costs. And in exchange of a plea of guilty in count 1, counts 2, 3, and 4 are gonna be dismissed.
Mr. Martinez, is that the agreement?
We could have the amount for court cost.
320.
I haven't asked for it yet. I don't know what I'm gonna do, so I may do that. I may do something different because it's not a binding on the court, so don't get ahead of the court, please. Mr. Garza, before the court makes a decision, it's important that the court hear from you on anything that you would like to say. Is there anything that you would like to say?
No, Your Honor. Right now, everything is fine. Yeah.
All right. Mr. Garza, in your case, cause number 2025 CRB 538L2, the court finds that there is sufficient information in the record to permit the meaningful exercise of sentencing discretion. The court finds that you have pled guilty freely and voluntarily. The court hereby accepts your plea. You are now ineligible to possess a firearm ammunition. Your punishment is hereby assessed at 365 days in the Webb County Jail, but that's going to be probated for the term of 1 year. You are to complete an anger resolution classes. You are to complete parenting classes. You're to complete 80 hours of community service. You're requesting a 4-for-1 credit, Mr. Garza. Are you currently working?
Yes, sir.
What do you do?
Right now, fiber optic, sir.
How long have you been doing that?
A year and a half, sir.
The court grants you a 4-for-1 credit. Your court costs are hereby assessed at
20.
These are the orders of the court. Anything else on this case, Mr. Martinez? Anything else, Mr. Villarreal?
Nothing from the state, Your Honor.
Mr. Garza, that now concludes your case. The orders of the court are due on or before
August the 5th.
Don't leave here today without first talking to probation.
Yes.
Do you have any questions for the court, Mr. Garza?
No, Your Honor. Thank you.
I wish you well, sir.
Thank you.
Have a good day. It's good to see you, Mr. Martinez.
Page 1, number 1.
The state of Texas versus Bianca Erika Castillo, cause number 2025 CRB 1001 L2. Counsel, pull up in front of a microphone and tell me your name on the record.
Your Honor, Andrew Warshaw from the Webb County Public Defender's Office.
Mr. Warshaw, welcome to court. The court marks you present in person. Who is the prosecutor?
ADA Omar Villarreal, Your Honor.
Court marks you present in person, Mr. Villarreal. Speak into the microphone and tell the court, are you Bianca Erika Castillo? Welcome to court.
Sorry, the microphone is off.
One more time. Are you Bianca Erika Castillo?
Yes, Your Honor.
Welcome to court, Ms. Castillo. The court marks you present in person. The person to your right is your lawyer. Mr. Warshaw, what is the announcement in this case?
The state has agreed to dismiss the case, Your Honor.
Mr. Villarreal?
That is correct, Your Honor. We got an affidavit of non-prosecution from defense counsel, so state moved to dismiss this case.
Ms. Castillo, the court has received a motion to dismiss for the same reason, the exact same reason stated by Mr. Villarreal on the record. There is a complete withdrawal. The request is well taken. Your case, cause number 2025 CRB 1001 L2 is hereby dismissed.
Okay.
I wish you well. Have a good day.
Same.
Page 1, number 2, Your Honor.
State of Texas versus Roberto Esteves Jr., cause number 2025 CRB 290 L2. Court marks Mr. Warshaw present in person and Mr. Carlos Guerra present in person. Mr. Guerra represents the state. Mr. Warshaw, the defendant. Roberto Esteves Jr., are you present? Court finds
Okay,
defendant.
Your Honor, before you issue a KPS,
Court find, I can't do that unless I find him not present. Court finds defendant not present. Mr. Warshaw, go ahead.
Your Honor, the last time Mr. Esteves was present in court was April 20th, 2026. And we checked Odyssey. He was given notice for his next court setting on July 17th, which is tomorrow. So he never got notice of today's hearing.
Okay, understood. Have you been able to communicate with your client regarding this setting?
We have not been able to speak with him. He moved to Houston, and I personally had spoken to his brother, who still lives in Laredo. He tried to get in contact with him. But the numbers that we have for him are not good numbers. So we haven't spoken to him.
So tell the court, let me pull up the cause number, but it sounds like, and April was the last court sitting on this case?
Yes, April 20th. And he was given specific notice for July 17th.
I do see that. I just, what I don't see in the case file is a certificate of conference on an informal setting. Mr. Warshaw, was an informal conference ever held? Same question, maybe Mr. Guerra, do you know if an informal conference was held on this case?
Let me check my files, Your Honor.
As far as the records that I see, Your Honor, I do not see a certificate of conference.
I don't see that as part of the court files either. All right, so given that there's no certificate of conference on an informal setting, given that this case was scheduled on the record for July 17th, what is the announcement, Mr. Guerra and Mr. Warshaw?
Your Honor, as we understand, because there has not been any contact with the defendant, I do not believe that this is going to move forward tomorrow. We have we've offered PTD on this case. I think it's potentially if the client was here, the defendant was here, he might agree with it, but we have no way of knowing. And I believe the defense has no way of preparing as well for a trial tomorrow without their witness.
Well,
I would move to dismiss this case on the basis that the state never made an offer. This was the first time that they ever made an offer in this case, was when it was set for trial.
Your Honor, we've made offers before. We have spoken, we have conferred with counsel. They have come to the office. We have tendered offers, and we have even negotiated and lowered the offer. The offer used to be probation, 1-for-1 probation.
Well, I think the reason the court was asking the question on the certificate of conference is because exactly of this situation. There is no way for the court definitively, I mean, unless I put the lawyers under oath, definitively to know whether an offer has been made, hasn't been made, it's been offered, it has been related, has been contemplated or not. One of the reasons, or one of the main reasons, besides in the interest of justice and the ability to communicate with persons that are accused, that they have something in writing that they can then think about, contemplate, consider after advice from their lawyers, is so that there's some structure and definitiveness to cases before they get this far. And now I understand why this case got this far without a definitive answer, is because there is no certificate of conference, which could have, may not eliminate all uncertainty, but it would have minimized the probability of going to trial. So I tell you what, in the interest of justice, the court is going to hold off on a capias. The court is going to release the jurors, knowing that defense has not been provided sufficient or ample time to confer and prepare for a defense in this case. But it is going to stay on the court's docket for tomorrow at 8. If defendant is present, then you can, I'm going to order that you communicate, and then just advise the court on the record that communications are ongoing. If defendant isn't here at 8 or shortly thereafter, the court will issue a capias. Thoughts, comments, questions, or objections, Mr. Warshaw?
None, Your Honor.
Same question, Mr. Guerra?
No, Your Honor.
All right, so we have 2 cases. So the court is going to release all jurors, and this was so that you know, counsel, this was very important to the court. I do this because obviously each case is important. The administration and effective of justice is important, but on top of that, this system will not survive unless we have sufficient jurors. As you know, a couple of weeks ago, there was several jury trials set up in this county, and one of those wasn't able to be made because of insufficient persons showing up. And it's so important to this court, and I would presume for all, is that there is much faith and confidence in the system, so that when people get the notices that they actually do in fact show up, that's not going to happen over and over again if we just release on the day that they're called. So this was very important to the court to know that we can now release these persons and that they'll continue to answer the call when next summoned for jury trials. I'm going to call this case tomorrow at 8, and the other case. Anything else for the record, Mr. Guerra?
Nothing further, Your Honor.
Mr. Warshaw?
None, Your Honor. Thank you.
All right, we'll call this case at 8 a.m. Thank you all. Ms. Rodriguez, have all cases been called on today's docket?
Yes, Your Honor.
This now concludes this docket held in person and by video conference for Thursday, July 16, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court, like pretrial services, probation, the clerk's office, the sheriff's office. For the lawyers still present, Mr. Guerra, Mr. Villarreal, Ms. Martinez, and Mr. Warshaw, the court appreciates your service. Thank you all.